Hey. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting in Boston within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning, everyone. If that's working, welcome to the Appeals Court. I am Justice Rubin. To my right, Justice Neyman. To my left, Justice Tan. We will be hearing 6 cases this morning. The rules, as they always are 15 minutes per side with no rebuttal. If parties are dividing their time on one or another side of the case, you should let us know at the outset, although we already have some purported information about that here. That is usually correct, but still. We have read your briefs with some care, so you may want to get into your argument rather than spending a lot of time on the facts, but it is your time to do with as you wish. So, with that, we will hear our first case, number 24-851, and this is Commonwealth versus Maddox. We will hear from Attorney Oresti.
Good morning, Your Honors. Megan Oresti for the defendant appellant, Mr. Jonathan Maddox. We're appealing his conviction of assault and battery on a police officer on several fronts. The strongest and the first I'd like to talk about is the sufficiency of the evidence. So even in the light most favorable to the Commonwealth, evidence clearly established that at the point when Mr. Maddox's arm touched the officer's neck, he did not have the requisite knowledge that he was interacting with a police officer, which is one of the elements of the crime. We would argue that the evidence here, even before the defendant testified, overwhelmingly supported the opposite. Both of the Commonwealth's officers testified that Mr. Maddox acted and stated that he believed he was being robbed.
Counsel, though, wasn't there testimony? So there 3 witnesses testified, right? 2 officers for the Commonwealth and the defendant testified on his behalf.
Correct.
Both officers, didn't they give consistent testimony with one another that they identified themselves?
Yes.
Upon their approach to the defendant?
Yes, they both said that I said they were Boston police officers. However, they were dressed in plain clothing and confirmed that they had their badge and gun and so forth under their undergarments. I think that they probably, did say they were Boston police officers. It is very not clear within the testimony whether Mr. Maddox saw them flash a badge or not, but I think we don't really even need to speculate on that because the evidence clearly established that Mr. Maddox said, "You're trying to rob me." It's a chaotic scene, tens of thousands of people coming out of a concert. He's approached by people saying they're officers and to hand over merchandise that he bought legally within the venue, and he's otherwise acting a good citizen. And so I think that we don't even need to speculate whether they said that or he saw a badge because—
Well, how is that speculation under the Lattimore standard when you have Officer Niles testifying? Multiple times we identified ourselves Boston police officer. I raised my shirt multiple times, showing that I had a badge and my firearm and my radio. Furthermore, he testifies towards the end of the interaction, this is subsequent, he acknowledged that he saw my badge and gun. Under the Lattimore standard, that's not speculative. We have to accept that.
I would agree. I would argue that on page 117 where you're referencing, he's stating he acknowledged he saw my badge. It's not clear that he saw the badge before the interaction happened. He was cooperative. As soon as he realized they were officers and he was OC sprayed, and he actually says they handed me the badge and he apologized and was compliant, which I think also goes to the fact that if he was compliant when he understood they were officers after he was OC sprayed, why wouldn't he have been cooperative earlier on in the interaction if he understood that he was interacting with officers at that point?
There was testimony that there were bystanders shouting, "Let them do their thing, let them do their job," or something to the effect.
Well, no, there were bystanders. Once the OC spray was deployed, a crowd had gathered and said, "Just do what they're telling you" at that point.
What they're telling you, yes.
At that point, but that's not the point at which, that was after he was OC sprayed. I think when you have the testimony of the officer saying this all happened within a few minutes, saying he thinks he's being robbed. I don't think we have to speculate whether he saw the badge or not. Even if he did, the standard under this law is that it's not a reasonable person. It's whether this defendant understood that these were officers he was engaging with. And he, based on the evidence just in the testimony of the Commonwealth, he was believing he was being robbed and reacting as such. And as soon as he realized they were officers, he complied and was cooperative. And I think that shows that had he understood they were officers earlier on in the interaction and not somebody else, dressed in plain clothing trying to take something he bought legally.
Once he realized that the officers, he had the officer in a chokehold from behind and was then maced and then became cooperative.
Yes, because he then realized he was interacting with officers.
That's one interpretation. Another interpretation was he knew they were officers and he acted the way he did. And that's a question for the jury, isn't it?
I think it is, and I think the jury really struggled with it in this case. They came back twice deadlocked. They wanted the more definition around what does it mean that the officers were acting under the color of their authority, which I have another sufficiency argument on that. But I do think this was, even with just looking under the Lattimore standard, these officers said this man thought he was being robbed. And this all happened very quickly, and once he realized they were officers, he complied. And I think that goes to show that he really didn't understand these were police officers until after he was OC sprayed. And I would also add that the case deteriorated once Mr. Maddox took the stand in his own defense. And not just that he offered a counter set of facts, but he added things that made it even more likely that he didn't understand they were officers. He was otherwise acting a good citizen. He was having drinks at a concert. He ordered an Uber. Just prior to the interaction with these officers, he had stopped a uniformed officer to ask for directions to his Uber location. That is not the those are actions of a responsible citizen, not somebody who's going to unprovoked attack a police officer moments later. So we would argue that the case deteriorated even more when Mr. Maddox testified. So that's the element of knowledge. We also argue that the element of whether these officers were acting under the color of authority was not sufficient. The evidence was not sufficient to support that. And the reason why is that the police officers, as agents of the state, derive their powers by enforcing statutes, regulations, judicial orders, and this injunction that they were allegedly enforcing was expired. It was long expired. The officer says on the stand that he didn't verify that it was valid. On page 77 of the transcript, they didn't look and see that they were enforcing a valid law. I didn't find a criminal case totally on point with this argument, but I would point the court to look at the Doyle case that this court decided, where two uniformed officers were acting as bouncers on a detail at a club, and one of the officers was found not to be acting under the color of his authority in his actions, and that it was a question for the jury to decide.
Right, I was just about to say, I recall that case, and was the holding actually that he was not acting under the color of his authority, or was the actual holding that is a jury question?
It was the holding that it was a jury question. I think that there's a law that comes out of it, but I do believe the case decided that one of the officers, who was the chief, was acting under authority in that case, and one of the officers was not. Was acting more in the interest of the establishment, of the private establishment of which the detail was.
And I say our conclusion was that he was not, or that is a jury question?
That the jury could decide that. And I think the jury did struggle with that here. I do believe the judge could have given better instruction around that. They came back deadlocked. They asked, I believe it was 3 times, including in writing, what does it mean to be acting under the color of authority. And I would also urge this court to think about the Fourth Amendment cases when looking at this argument, because I believe we have lots of cases under the Fourth Amendment where officers were deemed not acting under the color of authority when they're executing a search warrant that has expired. So it's similar in the sense that
Do you cite any of those?
Yes, I do.
Okay. I'll find it in your brief. It's okay.
Okay, yep, no problem. I could probably pull one up here for you, because I did bring my list of cases. Give me 1 second on that. Sugar. Okay. It was the Mangret case.
I see it.
Yep,
yes, thank you.
reliance on outstanding warrant that had been recalled. So that is our argument on sufficiency, and we do also make an argument that there should have been a self-defense instruction. The Commonwealth believes that because we didn't proceed on that theory, that it wasn't warranted. However, I think the law is that in circumstances where evidence supports a claim of possible self-defense and unnecessary force by police, that the judge sua sponte should give that instruction. And I would argue here that there was a substantial risk of miscarriage of justice by that not being given, because the jury was struggling, and if they had been given the option to say, was this defendant just believing he was being robbed, protecting himself, the verdict may have been different. My very last argument is something you usually see in a motion to suppress, but I think because there's a strong constitutional reason to look at Fourth Amendment rights to unnecessary search and seizure, I would say that they didn't have reasonable suspicion for the stop, and that his actions and the kerfluffle that happened afterwards was fruit of the poisonous stop. They had not observed him selling anything or interacting with potential sellers. No knowledge specific to this man being a seller. He wasn't even carrying a large amount of shirts. He had 2 shirts for himself and 1 each for his children. They had a vague tip that a white man with a beard might be selling T-shirts, but in a crowd of tens of thousands, I would argue, and a defendant who wasn't acting criminally suspicious, that the stop was not based on reasonable suspicion or the seizure, and that the jury should not have heard testimony of what happened in the interaction that followed. Wow, I never finish early, but is there any other questions I can answer?
I see none. Thank you. Excellent
Okay,
argument.
thank you so much for your time.
And we will hear next from Attorney Tomasini.
Good morning, Your Honors, and may it please the Court. Michael Tomasini on behalf of the Commonwealth. I do want to begin my argument dealing with the sufficiency arguments, the knowledge that the defendant was dealing with police officers and that they were acting in the performance of their duties, as that those 2 arguments are what the defendant has keyed in on appeal. As far as the knowledge argument, officers began each encounter that evening and testified they began this encounter the same way. They identified themselves as police officers. They displayed their badges. Officer Morgan took his badge out from a lanyard around his neck, and Officer Waddy-Niles testified at least 3 times he lifted up his shirt to where his badge was located underneath that shirt.
Not all of which occurred prior to the assaultive behavior, right?
That is accurate. He testified.
So the question is, at the time of the assaultive behavior, what was his subjective knowledge, right?
Yes.
Okay.
But where, as in this case, knowledge isn't something that we have direct evidence of, we must rely on the inferences that can be made based on the officer's testimony and the statements made on scene, particularly that Officer Waddy-Niles testified that the defendant told him in the aftermath of the assaultive encounter that he had seen his badge and he had seen his gun.
Was it clear that he was saying he had seen it prior to the assaultive behavior?
No.
Okay, so
but
can we stick to things that we know about prior to the assaultive behavior?
in the light most favorable to the Commonwealth, natural inferences could be drawn that when an individual...
But there's no natural inference that that happened before, in the defendant's testimony, that happened before, or even in the officer's testimony, that the 3 times happened before the assaultive behavior.
Yes.
That's not a natural inference.
But what is clear is that the officers both testified consistently that they announced themselves, explained the reason for
Okay.
the stop, and displayed their
He
badges.
must have heard something because he said out loud, "I don't believe you're police." Maybe not those exact words.
Yes, I
But
believe
it's
he
clear
said,
from the
apologies.
officer's testimony that he was saying he didn't believe they were police.
Yes.
Okay, so let's assume he either heard them say it or saw the badges, understood that they were representing themselves to be police, right?
Yes.
So then the question is, can a person to whom those representations are made Can they believe that someone is not the police? Or not even can they, because it's subjective, but okay, can they?
In the light most favorable to the Commonwealth, where the defendant is making self-serving statements on scene, I believe the exact quote was, as testified to by Officer Morgan, "I didn't believe you were actually real police," that does have a natural inference that he is able to see the badge, is able to see the gun.
But he has to believe they're real police or he can't be convicted.
Yes.
Okay. So he says, and I agree, it's everything everyone says on the stand is self-serving. So this is also self-serving. He testifies on his own behalf and says, or he did testify, I don't know whose testimony was, that the exact words were, I didn't believe you were real police officers.
But where it is a question for the jury, any rational jury could credit the officer's testimony that he had seen everything he needed to understand, to appreciate, to believe that he was dealing with police.
So now the question is, was there sufficient evidence? I see some evidence here, obviously. Was there sufficient evidence that a jury could find beyond a reasonable doubt that he knew? Right?
Yes, and I would argue the accumulation of that evidence, the fact that he had seen the badges, the fact that the officers had announced themselves, and the fact that he made what I would argue is a self-serving statement that they weren't actually real.
Why was he hitting the police officers or choking them, or your witnesses say choking him? Why did he engage in assaultive behavior in your theory?
The defendant relies in their brief on the idea that because someone is being robbed or thinks they're being robbed, that they can't possibly understand their.
I didn't ask you that. I asked you what your theory is of why he assaulted these two officers.
So what I'm trying to say, and to answer that question, is that the defendant thinking he is being robbed does not mean that he doesn't recognize, doesn't understand that he's dealing with police. I don't see those two things.
I'm sorry, so if you're being robbed by the police, I don't even know what that, I mean, I guess I can imagine what that would look like. I suppose somewhere there are corrupt cops who are robbing people. And you think that if you resist the robbery, that's assault on a police officer?
Where an individual, who in this case has had a few too many to drink and has an officer physically seizing his property from his person.
Unlawfully. No reasonable suspicion, no probable cause, certainly, and he's seizing property.
He's
So
doing
someone
that
comes up to you, you're carrying for your family some T-shirts, 4 of them, or 3 or 4, I don't remember, because you have kids, and the police officer comes up to you, you haven't done anything, you don't even know about this injunction, but which of course isn't valid, but you don't know anything about it, so without suspicion, people dressed as regular people come up and grab your stuff. And let's keep going, and they say they're police, but you hit them. Why doesn't that create reasonable doubt for any reasonable juror whether he knew they were police? Why would he be hitting them if he knew they were police? I am baffled by this.
I think an important distinction to draw is this individual who testified himself, he had I would argue, a few too many to drink.
Mm-hmm.
Has an officer who has identified himself as a police officer come and physically take his property from him.
If because he had too much to drink, he didn't know it was a police officer, he's innocent, right?
If he had consumed so much alcohol to be unable to understand.
No, I'm asking, since subjective knowledge is the element, if he didn't know it, but it was because he was loaded. He still didn't know it, right?
I would argue in that example, we would need overwhelming evidence of intoxication, and I don't think that's present here.
Okay, so go ahead with your argument is based on intoxication, so go ahead.
He testified that he had 3 drinks, which is enough, I would argue, to affect an individual's judgment and decision-making, but not their ability to appreciate what's happening around them, to have a rational conversation with those officers.
And so
he makes a snap decision to try to get his property back, and
why does he do that if he knows they're police? If he knows they're police, isn't there reasonable doubt? Because he's going to get his property back if they're the police. It's just some T-shirts he bought inside the place for his kid.
I do want to draw the distinction between, under the Lattimore standard, this court being required to draw all reasonable inferences in favor of the Commonwealth.
Okay, I agree with that, but one of the facts, you can draw an inference any way you want, is that, alleged facts, is that he assaults the police. That's a fact that we have to figure out whether it creates a reasonable doubt in any reasonable juror. And I cannot understand a theory for why he's assaulting the police if he knows they're police.
It is not, at this point, my position to speculate why he did what he did.
You have to draw every inference in your favor. So let's
Only
say I'm
that-
drawing the inferences.
Not to speculate why he did what he did, only that he knew from the objective indicators around him, from what the passerby, the crowd that had gathered, were plainly able to see that he was dealing with police officers asking.
Not the one who called the police.
The female by whom he was accompanied called the
Police,
police.
as did another bystander.
Yes.
Okay, so when you say everyone knew it was the police, we have two people, at least, calling the police because they think it's a robbery.
I would push back on that just to the extent that calling 911 has innumerable possibilities, including calling for aid for someone who had just been pepper sprayed or calling for additional officers.
If the police are already there, you don't call 911. I mean, you might, we can imagine, people do crazy things all the time, right? But if it's the police doing it, why would you call 911?
You would still call 911 if emergency aid needed to be given, as EMTs ultimately did respond to the scene and administer aid for the pepper spray.
And they were in response to the 911 call?
The officers had called for backup and called for EMS.
So the officers had already called for EMS. I mean, I'm just trying to figure out, it seems so odd, the behavior that you're hypothesizing, that I'm trying to figure out if for any reasonable juror it raises a reasonable doubt. I'm trying to figure out why someone who knows these are police assaults them. And I understand why you assault someone you think is robbing you. I mean, what you say in your brief is something like to cover up his assaultive behavior, but he assaulted them before, like he didn't have to engage in assaultive behavior.
But if I take the court's logic that
Well, it's not the courts, it's just me, and I'm just throwing out a hypothetical.
the notion that the defendant was dealing with a police officer renders it impossible that he would try to get
Not
his...
impossible, but just, you can't say beyond a reasonable doubt he knew.
But
Because he fought with the guy for no apparent reason if he was a police officer.
where reasonable inferences are to be drawn in the favor of the Commonwealth, it is not beyond a reason. It is certainly a natural inference that an individual whose property had been taken from him by police, who has had a few to drink and is making a snap judgment, would try to get that property back and would go after the individual that had done it. And that's exactly what appears to have happened here.
The police.
Yes.
I mean, I don't know. That doesn't seem, I don't know. Instead, he's hitting them and saying, I don't think you're real police. I mean, I don't know. I mean, I hear what you're saying. And obviously, we do have to draw every inference in the Commonwealth's favor.
Yes, Your Honor. And if I may move on to the second sufficiency argument made by counsel as to whether the officers were acting in the performance of their duties at that time. The testimony indicated that they were working a paid detail at TD Garden. They were in plain clothes, but they were equipped with their badges, their radios, their firearms. Officer Waddy Niles testified he was just a Boston police officer working that night, not unlike an officer working crowd control at a baseball game or loss prevention at Stop and Shop. These officers were working with a third party to enforce trademark laws to prevent counterfeiters from unlawfully profiting from others' intellectual property. those officers were being paid by Boston Police to conduct.
I thought it was agreed that there's no criminal offense here.
There was
That
no
it's-
criminal offense.
Okay. So we do have this case that I've looked at, which is Mingret. I know that's a suppression case, but it says expired warrant. A seizure's no good. This is expired injunction. So let's say the seizure's no good on that ground or on the probable cause ground. What's the remedy?
So I would answer that question in two parts, given that it is pertaining to the seizure and to the motion to suppress was not filed or litigated here. We are in a substantial risk of a miscarriage of justice. A standard of very likely that the outcome would be different had the defendant filed and argued that motion to suppress. I would point, Your Honors, to the brief where I specifically point out the attenuation doctrine.
Was there a Rule 30 filed here?
Not to my knowledge. Where the defendant is himself responsible for the conduct, violent assaultive conduct, he cannot suppress his own illegal actions, and I think the case law is clear about that. The King case and the Holmes case, which I cite in my brief, where regardless of whether or not there was a potential issue with the seizure, with the stop, the defendant making a decision to attack police officers is not conduct that the exclusionary rule is designed to prevent, and it isn't something that the court should be protecting, where the defendant put the officer into a chokehold. I would note, as far as the performance of duties and the sufficiency of the evidence, that the cases defendant relied on in their brief, Doyle v. Quincy, also Davis v. Del Rosso, do note the scope of an officer's employment should not be construed restrictively, as Justice Neyman pointed out, is often a question for the jury, and that except for very plain cases, which I would argue this is not, those are determinations for the jurors as question of fact.
The jury had to determine as a question of fact. I'm sorry, your time has expired, but I have a question. And I've also dominated the argument, so if anybody else has a question, they're free to ask it as well. The jury were supposed to determine whether as an element of the offense, whether they were acting in the performance of their duties?
Yes, that is a question.
Were they instructed on that?
As part of the standard instructions for assault and battery in a police officer, the sixth element is whether the officers are performing.
I see. So they were instructed they had to find
Yes.
that. And doesn't Mingret indicate that if you're operating in that case on an expired warrant, in this case we have an expired injunction, that that's not acting as part of your duties?
I would point, Your Honor, to the Bonitez case, which does say, absent an egregious abuse of authority or officer actions that are divorced from a legitimate law enforcement function, they should be found to be operating in the performance of their duties, absent anything that strips the officer's actions of their official character.
Okay.
Thank you, Your Honors.
I have nothing else. No one has anything else. Thank you very much.
I'll argue.
Excellent argument.
Parties.
Very interesting case. Unusual case. The case is submitted. Our next matter is number 24-695. And this is Commonwealth versus Benitez. We will hear first from Attorney Shack.
Good morning, Your Honors, and may it please the Court. My name is Tom Shack, and I represent William BENITEZ. I'm accompanied today by my law partner and sister, Nancy Shack, Esquire. This is her first appearance in the appeals court here in
Your
Massachusetts.
actual sister.
My actual sister.
Oh, okay, terrific.
Not one of our nuns when we grew up, Judge.
No, but, well, okay.
Okay. So, in any event, may it please the Court again, the fact is that this is a very complicated, very brief but complicated case. And specifically, it's a bench trial. It takes place over the course of one day. By all accounts, it should be a fairly straightforward and simple matter. However, it became very complicated quite quickly in the proceedings. And when I say that, I mean the evidence that the crime was committed and the evidence relied upon by the trial court in its verdict was based upon the testimony of an 11-year-old child. That 11-year-old child was testifying to events that had occurred some 4 or 5 years before that, when she was 5 years old, or in that range. At the same time, Mr. BENITEZ had been incarcerated twice. He's the stepfather of this young woman, this young girl. He is incarcerated twice for assault and battery on this young girl's mother. It's a domestic issue. It happens twice. The first time he takes responsibility and pleads out to that domestic assault. Is sentenced, spends over a year incarcerated in the House of Correction, and then he's released with a broken leg. He breaks his leg in custody, or has his leg broken in custody, and then he goes back to he's picked up by the original victim, by the mother, as we refer to her.
So we're well aware of the facts, and this was brought out before the jury, and it seems to me that you're stating, at least in part, that there was a motive for the mother to lie, basically.
Yes, Judge.
Okay.
Yes, Your Honor.
So that's a jury question. So now let's get to the heart of your argument.
Well, so the judge relied in his verdict upon the exclusive testimony of that young child. And you, being familiar with the facts, you know that the verdict was quite extensive. The language of the verdict was quite extensive. And in that verdict, the trial judge said, this is a young girl who obviously, to him, obviously has learning disabilities. And it should be noted, of course, going back to her testimony, there was conflicting testimony based during direct examination, cross-examination, and back and forth. She was confused, dramatically confused on a number of occasions, but testified equally that there was no penetration relative to this underlying charge. And she says it twice. I mean, she says it didn't happen twice. She said, and then under direct, she's led through this process again. She's through leading questions, she's brought through this again. And she corrects her testimony. I mean, in other words, she's appealing to try to answer the questions that are being asked before her the way that people who are asking the questions want to be, how they want to be answered. And the problem is that it combines. It's a collaborative issue because the mother testifies during direct examination that this young woman has learning disabilities, but they are, quote, not dyslexia, and that's also referenced.
That was elicited on redirect examination?
Yes, Judge, it was elicited on redirect.
But the
That was in
defense,
response, I'm sorry, but that was in response to part of your predecessor counsel's cross-examination where he elicited the fact that He asked, how does the child do in school? She's improved. Was she having difficulty in school? She had to repeat first grade. What years? There was a whole line of questioning. So on redirect, I think the prosecutor was arguably entitled to clarify as to why.
Certainly no doubt that you could provide an answer that's non-scientifically specific. And that's really what our concern is here, Justice Neyman. We are in a position where the defendant, this really doesn't boil down in our case to a question of guilt or innocence. Obviously, it comes to whether or not he got a fair trial. The question becomes whether or not that information, the information that she does not have dyslexia, that itself is a scientific diagnosis. So that, in other words, so Your Honor, you can discount completely the issue of whether or not she may have dyslexia. But she has something else, and we don't know what it is, and the judge isn't being told what it is. He's not being told what the symptoms are. He doesn't have the benefit of an expert who can provide insights into why she may or may not be capable of testifying accurately. And the voir dire of this child during the motions in limine or at the beginning of trial were very sort of standard, adult-type questions that you would ask. You promised to tell the truth.
How do we begin, though, to evaluate this, whether or not there was a learning disability, the impact, the prejudice it may or may not have caused, why counsel did or did not object to this without a motion for new trial?
And, Your Honor, I understand that, but I think that the motion for new trial here, because of the nature of the verdict and the judge's findings, and specifically because of this is a jurist verdict, it's our position that the appeals court under Rule 4 was the right place to bring this argument.
You had a question, Justice?
No, it was covered already. Thank you.
Sorry. May I continue? Thank you. Apropos of what we were discussing, Your Honor, the fact is that this determination that this young girl has, it comes out in several other ways too. That's also part of why we're here under Rule 4, seeking relief under our full appeal, or our right to full appeal, is because there was a SANE examination done too. Of course, it was done well after the fact. And the SANE examiner testified at trial that the absence of injury, and in this case there was no sign of injury, but she testified to the fact that the absence of no injury does not mean that the event did not occur. And respectfully, I would suggest to you that because the expert was because this witness was precluded from giving expert testimony before trial, under the defendant's motion, she then gives that professional opinion, saying, it's basically saying, in my experience, not having damage, that doesn't really mean anything to you from a guilt or innocence, particularly from an innocence standpoint. So, Your Honor, I would respectfully suggest that Mr. Benitez is now entitled to that relief because we don't know what the nature of the underlying ailment is. The judge never did anything more than ask whether she would tell the truth. Never did any deeper voir dire into the nature of her ailments. And as a result of that, I would suggest to you that the case should be remanded and or overturned. So on that, I would rest on my brief on the rest of the argument.
Okay, I see no further questions. Thank you very much for your argument. We will hear next from Attorney Herron.
Good morning. May it please the court, Donna Marie Herron, Assistant District Attorney representing the Commonwealth. There was sufficient evidence here to sustain the defendant's conviction of aggravated rape, where there's 11-year-old at trial, 6-year-old at the time, testified unequivocally that when she was 6 years old, the defendant, who was 27 at the time, put his hand inside her private part, or the part she used to pee. That was more than sufficient to sustain the defendant's conviction, and nothing more was required. In regards to the learning...
You slow down a little bit?
Oh, I'm sorry.
That's okay.
Nothing more than her testimony is required to sustain the defendant's conviction. In regards to the learning disability, as noted by this court, that was completely opened by the defendant. Nothing was testified to that on direct of the mother. On cross-examination, defense counsel completely opened the door to that testimony by inquiring of the mother, how did the victim do at school? Did she have issues? Did she repeat the grade? And then on redirect, the Commonwealth was entitled and allowed to ask what exactly, why was she repeating, what was the school issues that made her repeat the grade? And what was said was she had learning disabilities and that it wasn't dyslexia. I would suggest the defendant, because he opened the door and introduced the subject, is precluded from challenging it on appeal. I would suggest that under the Bond case, a mother most certainly can testify to their daughter and that the daughter has learning disabilities. And given that this was a bench trial where Judge Gordon specifically found the victim credible, compelling, believable, that there was no prejudice from such testimony, even if this court were to consider it. And then in regards to the SANE nurse's testimony, again, the motion to eliminate, it was clear the judge precluded it because of lack of notice. That was the reason why the judge found that the nurse couldn't testify. The testimony was not elicited by the prosecutor, I would suggest, where he simply asked the SANE nurse, and what did you observe? I would suggest she, in a rambling answer, does for the twice say, and just because there's no injuries doesn't mean no assault occurred. But again, given that this is a bench trial, this court could assume that Judge Gordon, who issued the ruling, would instruct himself on the law and disregard any testimony that shouldn't have been given. Again, it was not elicited by the Commonwealth. It was more of a sua sponte or more of a rambling answer by the SANE nurse. And based on all that, the Commonwealth asked that this court affirm the defendant's conviction for rape of a child.
I have a question about the absence of a colloquy of the child victim. I mean, Attorney Shack's brief essentially says, look, this case screamed for the judge to conduct that colloquy sua sponte.
I would respectively disagree, Your Honor.
Well, I understand that, but what is the standard? When must a judge act sua sponte, if ever, in conducting a colloquy to determine the competency of or the ability of a child witness to comprehend truth versus falsity?
I would ask this court to look at the case cited by the Commonwealth, and I know I'm going to butcher the name, but the, I'm sorry, Lamontagne, from this court.
Lamontagne.
Thank you very much. In that case, it's pretty much the exact same as this case, where it was not raised below at all. The competency of the witness was not raised at all, was not objected to by the defense counsel. And this court stated, while a judge has the authority to sua sponte do a competency hearing, he is not required, or they are not required to sua sponte do a competency hearing, particularly where it is not raised below, it is not challenged below. The defense counsel did not object to that, and that was a 4-year-old in that case, Your Honor, did not object to the testimony of the 4-year-old, did not say that there was an issue with the 4-year-old's testimony, and in that case, this court said, well, the judge always has the authority to do it. He's not, or she is not required to do it. And I would suggest that here is the exact same case where there was no issue raised below as to competency. Just because of inconsistent answers, I think this court and the SJC have repeatedly said inconsistency does not render someone incompetent. It has to be so perverse that, their testimony is rendered unintelligible and beyond belief by a rational person. And that clearly, I would suggest, did not occur in this case. If there's no further questions, the Commonwealth rests on its brief.
I see none. Thank you very much. Excellent argument by both of you. Very helpful to us. The case is submitted.
Thank you, Your Honor.
The next matter before us is number 24-446. This is Commonwealth versus Verier. And we will hear first from Attorney O'Reilly.
Good morning, Your Honors. May it please the Court. This is Anne O'Reilly for the defendant, Raymond Verrier. Mr. Verrier is appealing the denial of the motion to suppress that he filed previous to his conditional guilty plea. The defendant pleaded to 3 firearms and ammunition convictions. The standard of review for denial of a motion to suppress is clear error, and the court reviews independently the application of the constitutional principles to the facts found. So there are basically 4 major issues before the court today regarding this case. The defendant was taken into protective custody. And the question is, which statute would apply? Chapter 111B, the alcohol rehabilitation statute, or Chapter 111E, the drug rehabilitation law. The defendant and the judge cited 111B. But however, there was no evidence that the defendant had taken any alcohol. There was some evidence that he might have ingested some other substances. There was some white.
What if the officer doesn't know? In other words, if the defendant's behavior may be consistent with both an overabundance of alcohol consumption or an overabundance of drug consumption, or possibly something else?
Or it could be both.
Or both, great. Yes.
The alcohol rehabilitation statute is several decades old, I believe, before the drug crisis. So the drug rehabilitation law, I believe, was passed in 2016, and there are no cases under that, as far as I know currently. Well, the important thing to remember is that the protective custody statute under both is written exactly the same. So the Commonwealth, so it requires that the defendant be incapacitated. So that requires one of the following 4: unconscious, in need of medical attention, likely to suffer or cause physical harm, or disorderly. And the Commonwealth argues that the standard should be reasonable suspicion under the alcohol rehabilitation statute. The SJC in Commonwealth versus O'Brien determined that the standard is probable cause.
So under this fact scenario that we have here, whether it's reasonable suspicion or if we decide it's probable cause, under 111E, would this not rise to the level of probable cause? The defendant is standing next to a busy road, he's swaying, his knees are buckling, he's trying to gain his balance, he has a white stain on his pants, a dark stain in his nostrils. He tells the officer that he overdosed a few days ago, that he's previously taken fentanyl, he's been up for the past 5 days, and that he's sort of swaying and unsteady again on his feet. It's raining. He's sort of standing there with his eyes closed, looking up at the sky. Would that not rise to the level of either reasonable suspicion or probable cause?
Well, generally, the cases have to do, the question is, okay, so he wasn't unconscious.
Right.
It's arguable that he was not in need of medical attention. He was not disorderly. He wasn't interacting with anyone on the street. He wasn't going into traffic or anything. So the other question is was he likely to suffer or cause physical harm? And there's not really evidence that would be supported, that would be supported. He was staring up at the sky.
It was he was next to a busy roadway, I think. There was traffic around. What should he have done? The defendant agreed initially to go to the hospital, but then changed his mind.
He did not give his consent to go to the hospital. And, the officer, these are difficult situations. And however, most of the cases regarding community caretaking there's a vehicle involved. It was decided several years ago the community caretaking function does not apply to the home. Generally, most of the cases are regarding, if the defendant is in a vehicle.
Right, but it's not required.
I'm sorry?
But it's not, just because he wasn't in a vehicle doesn't mean...
Somehow driving a vehicle or recently, Demos D, Commonwealth versus Demos D, the defendant was a juvenile who had been reported missing. He was in the back of a vehicle with gang members. He had been reported missing and he was a juvenile. So, the court held that that was the proper function of the community caretaking clause. However, here there was no vehicle. This is an adult. He wasn't a juvenile.
It doesn't need to be a vehicle. The question is, either was there probable cause he needed medical attention or probable cause he was a risk to himself, right? And that can happen on the street. You can find someone lying on the ground who clearly needs medical attention. So we have a bunch of facts found by the judge at the suppression hearing. And I think Justice Tan's question is, why don't they add up to probable cause that he was a risk to himself?
Well, the judge used reasonable suspicion, not probable cause. So.
I agree with you. Let's say we agree with you that that's the wrong standard, or assume it's the wrong standard. Why don't the facts found already by the judge add up to probable cause?
The police officer approached the defendant and started talking with him, and that's when he found out that the defendant, had taken recently overdosed, et cetera, et cetera. So
he's allowed to approach him, isn't he?
He's allowed to approach him, yes.
And ask him a question, right?
He is allowed to approach him and ask him a question. At some point, though, a seizure occurred.
Yes, I agree, but you don't say it was while they were having the conversation where he revealed that he had overdosed recently.
At some point, pardon me, the police officer decided to call an ambulance, and it wasn't immediately clear in the testimony exactly when that was, but I think, he got the defendant's attention initially because the defendant
wasn't
heard the
aware
radio.
initially that he was sort of coming up until he heard, the police officer's radio go off.
Heard the
right?
radio. Pardon me, he heard the radio.
Right.
So the police officer may have called the ambulance at that point. Initially, the police officer didn't ask the defendant if he wanted him to call an ambulance. He told him he was calling an ambulance.
After he had heard about the drugs, right? There's no reason to call an ambulance until he hears, I overdosed on, I don't know if he says fentanyl, but I overdosed a couple days ago. He's obviously out of it. He has pinpoint pupils, which the officer, I think, testified are a sign of drug use. So now we've got a person out of it, staring up into the rain. When he stands, he's buckling, he's swaying, and the officer calls an ambulance. Let's go to right before the officer called an ambulance. Why isn't there probable cause to believe either that he needs medical treatment? I don't know enough about that, but it seems to me someone who overdosed 2 days ago and is obviously high on drugs might need medical attention. I mean, there are things like Narcan that address opioid symptoms and so on. Right? I don't, so I'm just trying to figure out why you don't think this adds up to probable cause.
And Alfano versus Lynch, the First Circuit determined that intoxication is not enough to support probable cause.
Probable cause of what?
Incapacitation under the statute, under the protective custody statute.
I thought your argument was that there wasn't probable cause of one of those four things, not of incapacitation.
Incapacitation requires one of the four listed.
Oh, I see.
Unconscious, in need of medical attention, likely
Oh, I
to
see, I
suffer.
see. Those are, okay. And there's a First Circuit case?
Alfano versus Lynch, 847 F. 3rd 71, First Circuit 2017. Intoxication is not enough to support probable cause. Also, Nickerson.
How does that make sense in light of the SJC's language in O'Brien, where they say, and this is at page 622 of that decision, they say, to take someone into protective custody, officers need only probable cause to believe that the person is incapacitated within the meaning of Chapter 111B, Section 3, and the statute defines incapacitated as the condition of an intoxicated person who, by reason of the consumption of an intoxicating liquor, is 2, in need of medical attention, or 3, likely to suffer or cause physical harm or damage property. So I'm not following your argument in light of the SJC's language there. I mean, it specifically addresses probable cause in evaluating an intoxicated person.
There was no evidence that he was likely to cause someone else's physical harm.
Well, number 2, in need of medical attention.
In need of medical attention, there wasn't any objective, he wasn't unconscious, he wasn't lying on the ground, he was responding to the officer.
No, I understand that, but you just stated before, I'm trying to follow your argument that being intoxicated cannot be evaluated under the statute, as I understand your argument.
The standard is incapacitated, not intoxicated.
Right?
An incapacitated person can be intoxicated.
Incapacitated as the condition
But,
of an intoxicated
incapacitated-
person.
I'm sorry?
The statute defines incapacitated as, quote, the condition of an intoxicated person who by reason of the consumption of intoxicating liquor is, 2, in need of medical attention.
Yeah, that would be the alcohol rehabilitation statute. I don't have the exact language for the drug rehabilitation statute. Again, there was no evidence of alcohol consumption in the defendant's comments to the officer. He did refuse consent to be taken to the hospital, and he did refuse consent to the PAP frisk. And, the record, according to McCarthy's testimony, the defendant was not actively consuming narcotics or alcohol when he was first observed. The record does not establish the quantity of or anything of any legal or illegal narcotics that he might have taken. The defendant said he had taken Ambien and Tylenol PM. His consumption did not appear to impede his ability to converse coherently or relate
It appeared to
appropriately.
impede his ability to stand up,
He was standing up.
and his knees buckled and he
Well,
swayed.
He was swaying.
Might he have swayed into oncoming traffic?
He didn't seem to appear to be moving. He wasn't near.
He wasn't going to
was on
move,
the
he was just
sidewalk.
going to stay in the rain on those stairs? I mean, I hear everything you're saying, but I'm still trying to figure out why there wasn't probable cause either, that he was a risk to himself, or that he needed medical attention. Do you think that people who take drugs need medical attention if you find them right when they're so high that they're stumbling around?
I'm not a doctor.
I understand, but our case is about whether there's probable cause.
Would it establish probable cause of incapacitation? He was talking with the officer. He answered questions coherently, and the cases, do assess those factors. He was not walking into traffic. He was not harassing pedestrians, and he was. And McCarthy also did not administer a field.
He did OD 2 days before.
I'm not sure if he had overdosed a few days before.
A
I'm
few
not
days
exactly sure
before.
when.
And now here he is, stoned on drugs again. That might not be a dangerous situation, requiring medical attention?
The standard is incapacitated.
Yes, but requiring medical attention is one of the things that counts as incapacitated.
The standard is incapacitated, and the courts have held that intoxication is enough.
It's not
There's an argument that he
intoxication
was
alone.
intoxicated on drugs, not alcohol.
I agree with that. I don't know if that's worse or better or the same. But it wasn't intoxication alone, right? It was the swaying, the buckling, the pinpoint pupils, the recent history of overdosing.
He was able to answer questions coherently and to state that he did not consent to the ambulance or the PAT frisk. So I would argue that he was not incapacitated. Intoxicated, possibly not incapacitated.
Okay.
With that, I will rest on my brief. Thank you, Your Honors.
Thank you very much. I think we have your argument. We will hear next from Attorney Morris.
May it please the Court, ADA Bryn Morris on behalf of the Commonwealth. With me at council table is the motion ADA Kate Freeman. So I'll start with what the standard is in this case, because I think that is really the meaty issue here. The reason why the Commonwealth's position is that the standard is reasonable suspicion is because of what the officer is entitled to do under the drug rehabilitation statute. And that is send the defendant in an ambulance to a hospital. And it's that transportation to the hospital that the drug statute entitles the officer to do.
Does the alcohol statute entitle an officer to do that also?
So the alcohol statute goes far beyond, and in fact, under that statute, a defendant can be held in protective custody for up to 12 hours.
Okay, but you're saying that even though the SJC says it's probable cause, that if all the alcohol officer was doing was putting someone against their will in an ambulance and sending them across town to a hospital, that they can do that on reasonable suspicion?
So that's the Commonwealth's position, and let me explain further. So the SJC in O'Brien said to take somebody into protective custody, referring to holding somebody basically in a police cell at a police station for up to 12 hours, that probable cause is required.
Is there some other area of Fourth Amendment law where it matters where you hold the person? Or are seizures and they're measured by various standards, reasonable suspicion or probable cause?
So, Your Honor...
Only if it's a police cell, if the police hold you in the back of their car, it's not the same. If the police stand around your room in the hospital and don't let you leave, it's not the same?
So, Your Honor, all of the law on whether reasonable suspicion or probable cause is the appropriate standard looks to what is actually happening. It looks to the duration and intrusiveness of the stop or seizure.
Okay, the intrusiveness is complete denial of liberty here. Okay, right? It's a complete denial. I didn't even know that came up. It's a complete denial of liberty. You're seizing the person. I understand you're putting them in an ambulance, not in a jail cell, but I've never seen a case that says, oh, if you seize the person but you put them in a comfy chair, then you can do it on reasonable suspicion.
They're held against their will, correct, in protective custody under 111E.
So
until the time they get transported to the hospital or some other emergency facility, correct?
There is a brief detention until they are transported to a hospital.
They're not free to leave.
That's the same circumstances under a Terry stop where somebody is not...
No, it's not remotely the same circumstance as a Terry stop. A Terry stop, you stop the person to make a further inquiry. You don't lock them in an ambulance and ship them across town.
So, Your Honor, here, putting them in an ambulance is part of making a further inquiry.
I'm sorry, I am unaware of a case that says a Terry stop can include locking someone in a car or taking them to a hospital or doing anything except a brief stop for further inquiry. Are you aware, can you give me any case that says, oh, that was a Terry stop where the person was locked in something?
So, Your Honor, I'm not aware of a case precisely on point on that, but the point of a Terry stop is for an officer to confirm or dispel their suspicion. A police officer is not fully equipped to determine whether or not somebody needs further medical care.
What is interrogation? Isn't that to confirm or dispel suspicion? So can you hold someone on a Terry stop to confirm or dispel suspicion by questioning them in a police station?
No, Your Honor, I would say that goes beyond the purposes of a Terry stop. But here, the intrusion is still relatively minimal.
How far away was the hospital?
I don't know how far away the hospital was.
How do you know how minimal it was? Maybe the hospital's 10 miles away.
We know that this incident occurred in Chelsea, and so I think it's fair to
Okay, so you think there's a hospital there?
Huh?
Which one?
I don't know, Your Honor. That's not part
How
of the record.
far away was it?
It's not part of the record which
Well, I
hospital
don't
he was
understand
sent.
why you're saying it's a minimal intrusion. If I took you right now and drove you to the Brigham, you don't think that'd be a pretty big intrusion on your liberty?
I think that that would be relatively minimally intrusive. I think that that's a very...
But how would you get from there back to your house if it were near here? If you were a
mean-
drug addict with no money?
That's not explored, but I don't think that that's the question about whether or not this is minimally intrusive.
Presumably, you're not under the influence right now, so let's get back to your argument, which is,
You don't
as
seem to be.
as I understand it,
Yes, Your Honor.
you are arguing, first, that this is a 111E case. 111E controls, not 111B. Is that correct?
Yes, Your Honor.
My second question, do you agree that Commonwealth versus McCaffrey, which is a 2000 case from this court, has been at least circumstantially overruled by O'Brien, an SJC case in 2001?
So, no, Your Honor, and the reason why is McCaffrey dealt with what an officer needs in order to conduct field sobriety tests under the alcohol rehabilitation statute versus putting somebody in protective custody.
Okay, so even if it hasn't been overruled, you would agree that under O'Brien, in 111B, the standard is probable cause, correct?
I agree that the standard is probable cause to put
Or
somebody in
protective
protective
custody.
custody in a police cell. Yes, Your Honor.
Could you tell us, with specificity but succinctly, what is so different about 111E that we should apply a reasonable suspicion standard as opposed to the probable cause standard of 111B? Make the argument as clearly as you can.
Okay. So 3 reasons for that, Your Honor. The first is that the duration is substantially shorter. The second is that the degree of intrusion actually occurring is far less. And the reason why it's far less is because if you're going to be placed in a protective custody in a police cell, you're going to go through a full search of your person as opposed to just a pat frisk. And then third is the purpose behind it. When you're placed in protective custody in a police cell, that's not to confirm or dispel or anything like that. That's just to hold you until you've sobered up. Whereas here, it's the reason why you're being transported is because that's how you get medical care.
So is your answer to Justice Neyman's question, there is no difference? You think O'Brien, under 111B, doesn't reach putting them in an ambulance, and you're arguing that we should say reasonable suspicion when it's an ambulance under both statutes, but probable cause when it's a jail cell.
That's correct, Your Honor. In any event, regardless of what standard the court chooses to apply in this case, there is probable cause that the defendant was incapacitated, either because he was in need of medical attention or I should say, and because he was likely to cause injury to himself by nature of where he was standing. I believe this court is fully aware, based on the conversation with my sister, about all of the factors that suggest that he was incapacitated. The balance, sleepy trance, slurred speech, pinpoint eyes, the white stain on his pants and the dark substance on his nostrils, the fact that he had overdosed a few days previously and had admitted that he had previously used meth and fentanyl and that he was not used to substances like he used to. I'll also note for the court, just as a point of clarification, the testimony is that the defendant initially agreed to go in the ambulance, and it wasn't until after that conversation with the police officer that the defendant, and when more officers arrived, that the defendant changed his mind. And so that, rather than when the ambulance was called, is the appropriate moment that we're analyzing, the appropriate moment of seizure.
He can withdraw his consent at any time, can't he?
Yes, Your Honor. And what I mean to say by that is, there was no seizure until the defendant said that he wasn't willing to ride in an ambulance, and the officer said, no, you have to. I'm paraphrasing there.
Okay.
But that was the moment that the seizure occurred.
Can I ask this? I don't know that you're going to have an answer to it. I don't know what the answer could possibly be. How is a police officer supposed to know when there's either reasonable suspicion or probable cause that someone needs medical attention?
So officers are trained to recognize signs of opioid use, but they're not in a position to determine exactly what medical care is necessary. And that's why the drug rehabilitation statute says they get to send somebody to a hospital when they may be.
If they have, you say reasonable suspicion, or maybe your sister says probable cause, it's some level of suspicion. Does everyone who took an opioid require medical attention?
I doubt that any opioid use at all is the standard, but I think where there's substantial signs that the person may not be in full control of themselves, that we prefer that the officer send somebody to the hospital, and that's kind of the whole point of the community caretaking function.
Same with the drunk person.
So with the drunk person, there's more definitive standards outlined in the statute based off of blood alcohol level as well as the person's behavior.
Well, you can't draw blood alcohol without a probable cause.
So the officer under the alcohol rehabilitation statute first can do things like observe the defendant's behavior and conduct field sobriety tests. And then once the officer has probable cause that they may be intoxicated, a person is entitled to a breathalyzer test. And if they blow underneath a certain range.
They don't blow. They decline the test. Now what?
If they decline it, then it's based off of the police officer's observations. That's more of a right that a person has under the alcohol rehabilitation statute than a necessary
I guess it
component.
depends what they're doing.
Yes, Your Honor.
But so a police officer sees a drunk person stumbling on the streets, as can be done routinely late at night in most towns in America. Stumbling, maybe they're going to stumble into the road. Protective custody?
Yes, Your Honor.
Okay.
If there are no further questions, I'll rest on
I
my
see
brief.
none. Thank you. Excellent arguments by both of you. Very helpful to us. And the case is submitted. We are going now to take our traditional mid-morning break. We will return in 10 to 15 minutes. We will, at that point, hear the remaining 3 cases. Welcome back. We continue our sitting now. If I can find the right page here and the right thing here. We continue with number 24828, Town of Hingham Zoning Board of Appeals versus Housing Appeals Committee. And we will hear first from Attorney Ryan.
May it please the court. I'm Kerry Ryan here on behalf of the appellants, the Town of Hingham Zoning Board of Appeals, and the Town of Hingham. With me is Thomas Carey. The ZBA did not deny this comprehensive permit. Instead, it granted it, but it included a few conditions necessary for the protection of the health and safety of both the residents of the development and for the town. The first condition, which is the most critical condition, concerned excess nitrogen. It's a contaminant that was undisputed, the danger of the excess nitrogen. The excess nitrogen can cause death in infants, and generally known as blue baby syndrome. It's been linked to diagnosis of sudden infant death syndrome and fetal and birth defects and miscarriages. There's really no fight about the contamination itself. And one of the really dangerous things about this contaminant is that it can't simply be filtered out of the water. And that was one of the real concerns here, is that you have to treat the contaminant at the septic system
You
level.
say that the nitrogen will run to the gradient and into these wells. The other side has an expert who says it will run north into the ocean. Before the ZBA, whose burden was it?
Before the ZBA? I guess at the ZBA level, it was I'm not sure, Your Honor. Quite honestly, the burden would have been with the applicant, which would have shown that it would have objected to the condition. And then at the Housing Appeals Committee, the regulation is very clear which way the burdens go. First is the town has to show that it has a valid local concern. In this case, the local concern was the contaminant.
Yep.
Second, it has to show that the condition that it imposed was consistent with that local concern, which it did, which is the regulation is dead on, which is the septic system to treat that contaminant. And then the regulation goes on to then do a weighing analysis. The weighing analysis is you take the local concern and you also look in the weighing analysis at the degree of the concern. So it's the more important the contaminant, the more weight it will be given. And you weigh all of that against the
But the burden
need for
is on
affordable
the
housing.
Zoning Board of Appeals.
I'm sorry.
The burden, you think, is on the Zoning Board of Appeals.
It is, Your Honor.
So I'm trying to figure out, if I'm a developer, why don't I just put nothing in at any point, lose before the Zoning Board of Appeals, and appeal and get a de novo hearing where, with nothing in the record, the Zoning Board of Appeals can't carry its burden? Why isn't that a strategy that a developer might use?
I'm sure there are lots of strategies that a developer could use, Your Honor, and I'm not sure what all of those could be. I'm sure the
I
developer...
just said one. They don't put in adequate evidence, but there's no way to tell what's really going to happen. So on appeal, the board automatically loses.
Well, on appeal, if the board puts in evidence concerning the contaminant and the local concern, at the Housing Appeals Committee, if that concern is a legitimate concern and the regulation is directly related to it, it should outweigh the need for affordable housing, which is the Reynolds case, Your Honor.
But the board doesn't put any evidence on before itself before the Zoning Board of Appeals, right? So, for example, what I'm really thinking about here is the developer's purported basis for this northward flow includes two facts that we don't know the answer to. Are these 300-foot deep wells? I've no idea, and I don't think telling me that the average or the usual depth is 300 is really any use at all. Someone should find out. how deep the wells are? And do they have sanitary seals? Now, I don't know how you find that out. Someone had to install them. Maybe there's records somewhere, but no one has done that. And it seems like those two critical facts haven't been shown anywhere. Now, maybe it costs $1 zillion to find that out, which I would understand, but I don't think so.
Your Honor, I agree with you completely. Neither of those facts are in the record, and that is a very important point, because this entire decision by the Housing Appeals Committee relies on this one item, which is that these wells are put in at 300 feet deep in bedrock, and that is how Mr. Dillon made the analysis that, well, I guess the water's going to flow in some direction. But he admitted he did no analysis whatsoever. What he argued was, well, there's two different aquifers. Well, and so he was asked, did you do any analysis of the overburden aquifer? No. Did you do any analysis of the bedrock aquifer? No. Did you go look at the wells? No, which would have helped explain.
Well, of course they don't want to look at the wells. They like it better if we don't know. Now, maybe the board likes it better if we don't know also. I have no idea.
Right, that's my question. This may be slightly outside the record, but does your client have the ability to investigate the wells and see whether or not there are these caps?
The evidence that was presented, Your Honor, was that the wells were most likely installed between 1920 and 1980. The person that testified was from the Board of Health, Susan Sarney, and she explained that she did not have that information, but she doubted that those would have sanitary seals because of the time period.
Okay, we don't know.
I understand. Is that information, I'm just wondering, is that information obtainable?
It may have been, Your Honor, but I'm not sure if it would have required going into the homes of those abutters.
How are you supposed to meet your burden? Or is your burden only to show that they've never produced adequate evidence?
Your Honor, our burden is to show that it's the local concern that's legitimate and that our regulation directly ties to it. And the court actually agreed with us.
The balancing is your burden, right? This isn't about those first two things. It's about the balancing.
Right.
So you have to demonstrate apparently to this Housing Appeals Committee, you have to demonstrate to it that the local thing outweighs the need for affordable housing, right?
Correct.
So my question is this. Before the ZBA, no evidence on these two facts is put in.
I believe the evidence, Ms. Sarney did submit evidence at the Board of Appeals and discussing these various points, which was...
Did Mr. Dillon testify before the Zoning Board of Appeals?
I believe he submitted some evidence, Your Honor, and I do not know the exact evidence that he submitted to the Zoning Board of Appeals. He did submit, obviously, to the Housing Appeals Committee, which that evidence is in the record. And the Housing Appeals Committee actually specifically found that the town had legitimate local concerns, so that was the first part. The Housing Appeals Committee agreed. But then they said, well, we only find that there's a possibility of contamination. And that's where I think the Housing Appeals Committee went off the rails and applied a standard that was not the appropriate standard, and they made the legal error. The court standard is enunciated in the regulations, the balancing. But what the Housing Appeals Committee did was pick up the observation in the Reynolds case from this court that made the comment that it was more likely than not that the nitrogen would get to some abutter wells. And so when the Housing Appeals Committee picked that up, suddenly it started talking about things like burdens of, more likely than not.
Did they say more likely than not? I saw a lot of that in the briefs on the other side.
It said possible, right?
But in the Hack decision, because I agree with you, more likely than not is obviously not the actual standard for outweighing something, a risk of certain, well, a 30% risk of death of 8 people is going to outweigh the need for affordable housing, even though it's not more likely than not. It depends on what the risk is of.
Again, Your Honor, I agree with you completely.
Okay, but I didn't see that the Hack applied that more likely than not. I did see briefs on the other side arguing that that was the...
Quite honestly, Your Honor, I believe the Housing Appeals Committee standard became a mess. It mentioned the comment, well, it's a possibility that the contamination will go to the neighboring wells, but then it dropped the footnote, which was a major flag, which was footnote 31. In that footnote, it basically said, we're not going to order you to do it, however, we recommend you put in the exact septic system that was the condition. And then it went into a lengthy explanation of, well, if you don't put in the septic system, how about if you come up with a way to monitor the wells?
As I understand it, they're allowed to order different conditions, aren't they?
The Housing Appeals Committee could order different conditions.
So they could have said, well, okay, don't put this in, but test. After you do it, test and connect them to the public water supply if their wells get contaminated.
The problem with that, Your Honor, is that the regulations do not include any taking component. And so for the Housing Appeals Committee to say you're going to be able to go into somebody else's house and test, the Housing Appeals Committee doesn't have that authority.
Okay. Are the abutters anywhere in this proceeding?
They're not parties, Your Honor.
Are they aware of it even?
Yes. And
I assume they want clean drinking water, so they might let someone test.
Your Honor, it's not just the abutters. It's these potable wells, which are critical, where the abutters get their drinking water, but also the evidence was very clear that there's a potentially productive aquifer directly across the street, which ties into then the town's water supply. That's a very important thing.
Was that the $250,000 solution? Or is it?
The $250,000 solution is the advanced septic system.
Okay.
Your Honors, I tend to be a visual person, and so I would suggest that the one document that I would like you to look at in the record, because it might assist you, is a map which shows all the water surrounding this project, which is at Appendix V, or 710, page 710. That map shows the potential aquifers on the right. It shows the potentially productive aquifer on the left. It shows the pond just north of it. It shows the subbasin water all around it virtually. And so for Mr. Dilling to simply say, well, I walked by the place, and I think the water's going to go to the north, which even in that scenario, it's going to go into a pond then. So it just makes no sense that the Housing Appeals Committee could supposedly rely on that one comment to base its entire protection of the town of Hingham's residents and the residents of that development. And so that was one of the problems.
How much profit does the developer stand to make on this development?
Your Honor, that is an issue about the economics of the proposal. Whether the proposal was economic or not economic, the Housing Appeals Committee found that it was uneconomic.
Why don't you contest that?
Your Honor, we did not.
Why?
So we did not contest that. There are a whole host of reasons in the regulations of how that is calculated.
And you think it's correctly calculated as uneconomic? A
Obvious-
multi-million-dollar, I don't know how many millions of dollars of profit, project 32 units, a lot of units, and it's $250,000 for this thing.
Well, Your Honor,
in what sense is it non-economic?
you raise a good point, which is there are 32 units. Only 8 of them will be affordable. And the affordable component doesn't mean they're going to be almost nothing. It means they're going to be a percentage of the median.
80%.
Yeah. So but the town has not addressed the economics of it because the regulations have a very complicated formula. We have not raised that on appeal, so I don't want to give the impression that we're raising the economics, Your Honor. I don't want to be, misstating that at all. Because of the fact that
I have a question I need you to answer. We've danced around this, but the other side says Reynolds was properly applied here. You say it was not. Can you tell me succinctly why it was not? What is your best argument as to why it was not properly applied here?
Reynolds set up the 2 components that are critical in this case. One is excess nitrogen, and second is a 40B development. And then what Reynolds did was it weighed those 2 items and said, listen, you have a contaminant that is incredibly dangerous. And when you weigh that against the need for affordable housing, which it recognized, it weighs that you have to have that condition. So what the...
Invariably?
Well, no, it said that it was a legitimate concern and there was evidence that it could get into the neighboring wells. What the Housing Appeals Committee, I think, did in error was they recognized Reynolds from this court was the controlling precedent. It recognized the balancing test that its own regulations required, but then it went off to the side and said, well, it's a possibility. Why don't you just fix it? They put it in their footnote. And then there was the dissent that was again a flag. To my knowledge, I've not seen any other dissents in a Housing Appeals Committee decision. And in that dissent, it specifically said, you need to address this water problem.
Well, it's a dissent.
I'm sorry.
It's a dissent.
I understand it's a dissent, Your Honor. Obviously, it's not controlling. It was just simply a flag, just as the flag for footnote 31 was. I see that I'm out of town, Your Honor.
Well, this is a pretty complicated case. If there are more questions, I see you.
I would request that you reverse the land court and reinstate the conditions as previously by the zoning board.
All right. Thank you very much. Your time has expired. Thank you for an excellent argument. We will now hear, I guess you're dividing your time 10 minutes and 5 minutes, and we will hear from Attorney Croha.
Yes. Good morning, Your Honors.
It would be helpful for me if you would start by addressing my question. How did you comply with Reynolds?
Yes, Your Honor. The difference,
or how was Reynolds complied with might be a better way to phrase the question.
The major difference between Reynolds and this case is that in Reynolds, the developer said, essentially, I've met my burden to comply with state standards. And this goes a little bit to Justice Rubin's question earlier on as to the burden shifting component of it. The developer, when they appeal to the HAC, has the burden to prove that the development complies with state standards. That was done, it's not contested. So now it goes to the board to prove that there's a local concern that outweighs housing need. So answering the question specifically, in Reynolds, the developer said, I've met my burden for the state and I don't need to do anything more. So they didn't produce any evidence whatsoever to rebut the neighbor's expert who said the nitrogen from this site is going to hit the wells. And the Reynolds case uses the language more likely than not, but the testimony in that case said that the nitrogen is going to reach the wells at a level that's above what is acceptable from a local level. And so that sort of makes sense with Reynolds, the way that the case came down. This particular case is different because we do have an expert who said, and the HAC determined his testimony to be credible, and he said because of this host of different reasons, mainly the soil conditions, the depth of the bedrock, the way the water table comes in, it's not likely that the nitrogen is going to actually come in contact.
But you could find out, right? You could make sure that the wells are 300 feet deep and figure out if they have sanitary seals.
Potentially, if
so how can, and why are we? How can HAC decide something without that? And why should we be deciding on something this serious without knowing information that, now, if you tell me it costs $250,000 to get it, then I'll understand why, because apparently that's uneconomic. But I'm guessing figuring out if they have sanitary seals isn't going to cost $250,000. So why are we, I see there's this burden shifting and whatnot, why are we forcing HAC to guess about something where real people's drinking water could be contaminated or totally not, right? We don't actually know anything about the facts with respect to these wells.
So two answers to that question. Ms. Sarney did testify during the Housing Appeals Committee that essentially she relied on the GIS, the mapping tool for where the wells were relied on. She did say there were files in there. It wasn't really clear whether she looked at the files or not. I don't know if information on the depth and the sanitary seals were in the files at the Board of Health. If they were, the Board of Health could have produced them as part of their burden to show that there was an actual issue here. If the information wasn't in the files, my client wouldn't have the right to go onto the neighboring properties and do tests to figure out the details of this particular well. So the case really comes back to the burdens that are in front of, the burden shifting that's in front of the HAC and the presumptions. And so the presumptions that benefit the developer once they've proven that the project complies with state standards is that the board is obligated under the regulations and held up by the case law to, number one, prove that there's a local concern. Number two, prove that the local concern is based on a local regulation that has some justification about why state standards aren't enough. And then number three, the board needs to rebut the presumption that the housing need outweighs the local concern. And the board, so it had the burden to, number one, show that this nitrogen was truly an issue to the wells, and it required evidence to that point. And there was, with the HAC process, there was a back and forth with the pre-filed testimony, there was an opportunity.
Part of our review is substantial evidence review.
Correct.
There has to be substantial evidence supporting the decision of the board.
Correct, Your Honor.
And that's separate from burdens of proof.
So it's whether there's substantial evidence to support the HAC's decision based on their credibility determination as a finder of fact.
Okay, so if I were to conclude, for example, that the issue isn't Dylan's credibility, Dylan's perfectly credible. The issue is you can't figure out from Dylan's testimony whether the flow is really going to go north or go to the wells. Doesn't there have to be some evidence, right? A reasonable mind has to come to the conclusion that it's not likely to happen. And I don't see how you can come to that conclusion based on the average well depth in the region, or they probably have safety seals. Like, that doesn't actually, like, a reasonable mind comes to a question mark, not to a conclusion.
And those were certainly part of Mr. Dillon's testimony, but his testimony was also more clear than that, in that he said that the way that the soils and the bedrock and
It's
the water
everything together. It's everything together. It includes these premises about depth and seals.
And I understand that, and I'm not contesting that point, but what I'm trying to say is that whether the well was 300 or some other layer of depth, the fact that it was in the bedrock and that there was a soil cover that meant that the discharge would go to the soil or it would go to the water table, but it would not be able to get to the bedrock where these wells would have to be. And the average is 300, of course, and there's no evidence in the record of, I don't mean of course to that, of course, but there's no evidence in there as to where exactly these wells are located. But there was certainly testimony supporting that it was unlikely, and so, and I'm using the word unlikely, the HAC used the word that there was a possibility that it could reach the wells. But coupled with that possibility, which is certainly much less than Reynolds, and the Reynolds talks about more likely than not, but the more likely than not goes back, if you look at it, goes back to the 40B regulations.
Where did they come up with that word, possibility? Were there proposed findings of fact for the HAC made, and did they derive it from that, or
There was
elsewhere?
post-trial briefing. I'm not sure exactly where possibility came from. I think because it was a credibility determination between Mr. Dillon's testimony, Mr. Brennan's testimony, and Ms. Sarney's testimony. They didn't go so far as to say, we're going to believe Mr. Dillon that he really doesn't think that they're going to hit the wells, and we're going to say that there's a
That's
possibility.
not credibility. Like I said, he can be perfectly credible, but that can be not an adequate basis on which to conclude anything about these particular wells.
But he is an expert in the field as to how.
And if he had some data about these wells, then I guess he could tell us, well, maybe better what's going to happen. Was that same testimony presented before the ZBA?
It was not. No, there was. So
And are you allowed to do that? That is, they put a condition on because you haven't told them anything about it running north. So they reasonably enough think, well, geez then, okay, here's a condition. And now you come to Hack, and for the first time, you're able to say, oh, it runs to the north, and the burden's on the other side to prove it doesn't. You can do that?
So the process before the ZBA is that Riverstone asks for waivers from local regulations. This is a local regulation that Riverstone asked for a waiver, and there was information in the waiver request as to why it was Riverstone's position that this waiver was something appropriate because of the way the discharge was taking place and the treatment.
Based on what?
Mr. Dillon did not come to the hearings, but during the HAC process, you're allowed to introduce new evidence. So Riverstone had the first round of pre-filed testimony, introduced Mr. Dillon's testimony.
So your position is, yes, you can do what I just said, not raise something before the ZBA, and if they put a condition on it, then for the first time, raise it before Hack, and then the burden's on the other side, and if
Not
they have.
necessarily, Your Honor. So the local conditions need to be based on a local regulation. So the developer needed to have given the town notice of what it was asking because it needed to ask for the waiver. So the issue is quite before the zoning board, and the zoning board could have at that point had their public health person come in and say, that's not right for all of these reasons with details on the well that are in the control of the town and or the abutters. And just this, since I'm running out of time, the last point of it is that we look at the housing need, and the board also could have introduced evidence on the regional need that looks at supply and demand of housing, excuse me, versus the concern, and they didn't do that, and so the local concern also goes with the housing need.
I know your time has expired, but I have a couple more questions. In terms of the housing need, they attempted to put something in before Hack and weren't allowed to, is that right?
That's correct, Your Honor.
If it's a de novo hearing, why is the relevant date when the original permit was issued and not the day of the de novo hearing? You put in new evidence.
Right, so there were two issues with the new evidence. The number one is that it was introduced the week before, within the week before the hearing started, instead of the back and forth with the pre-filed testimony. So the developer never had a chance to take a look.
Is there a reg or something about how you're supposed to? I mean, I have never seen an HAC case before, and I've been here for 15 years. So how does that?
Right, so prior to the hearing, all parties have submitted pre-filed testimony. The hearing is only cross-examination of the pre-filed testimony. So going into the hearing, everybody's on notice.
Says a rule of the HAC?
Says the 40B regulations and the rules of the HAC.
Say that you do pre-filed testimony.
That's correct.
Okay.
And so the list of the subsidized housing inventory was not produced during that period. It was only produced the week going into this cross-examination, and we, the developer, didn't have time to take a look and see if what was on that list was even correct. So that was one part of why we filed the motion to strike. The second part is it was being produced as a basis for showing housing need, that the housing need in Hingham was less because they have increased their affordable housing. But the regulations say that the housing need is based on the regional need for low-income housing versus the need in the town itself as far as how many low-income people are actually in Hingham. And the Sunderland v. Sugarbush case talks about regional need, and in that case, they said that you look at, it was appropriate in the dynamics of that case to look at 6 towns regionally.
Okay, I get the point. Can I ask one other thing? Why was the condition removed that if the septic materials go under the roadway, the road has to be able to support the heaviest fire vehicle?
Riverstone's engineer, Mr. McKenzie, introduced testimony in his pre-filed testimony that the remaining conditions that weren't discussed in the HAC decision, including the one about the septic under the roadway, wasn't appropriate because it was a cost component that...
So you're going to build a thing with roads, but if a fire truck goes on it, it'll fall in. Is that right? Because it's expensive to do it the other way.
The project was designed to come up with to comply with the very in-depth state standards.
But not the heaviest fire vehicle that the town of Hingham has. The the road will collapse under its weight.
I believe it was a matter of the type of materials, but I don't recall the exact answer to that question off the top of my head.
Okay.
Thank you.
Thank you very much. Excellent argument. We will hear next from, who will we hear next from? Give me a second.
From Samuel Fergain, Your Honor.
Yes, from Samuel Fergain.
On behalf of the committee. I'd like to, given what's already been discussed here, I'd like to bring the court's attention to one line in the committee's decision. It's at page 1736 of the record. And the committee found that the board's expert had no evidence that groundwater would flow from the project to the wells in contention. There were 3 wells that were down gradient from the project, and that was a chief area of concern on the issue of nitrogen contamination. But the board simply engaged in conjecture. They never got close to reaching the threshold that was required from them to meet the burden to show that their concern for nitrogen contamination outweighed the need for affordable housing. The presumption that any local concern.
You don't defend the removal of any of the other conditions. Your brief is only about nitrogen.
Yes, Your Honor. I relied on the argument of Riverstone for the other conditions.
All right. Why was the condition taken off that the road has to support the heaviest fire truck that Hingham has?
I don't believe that was argued in any real depth on the appeal.
Why was it removed then by Hack?
I believe it was part of one overall condition that focused on the issue of nitrogen contamination, and it dealt with.
So you have no answer to my question for why you would remove the requirement that if the septic system is under a road, it still has to support a truck.
Well, it was part of the conditions that would raise the level of expense for the project to make it uneconomical.
So, but there's no one who says that there won't be any septic system under a road.
I don't think it was seriously argued at the appellate level.
And what was the expert evidence Hack relied on that you don't need a 10-foot setback at the retaining wall to put a ladder up? What expert evidence from anyone who knows anything about fire was put in?
There was no expert evidence that it was necessary because the local rules did not require it.
No, I think it's Lieutenant Napoli came in and said that's how it's done. My experience is that's how it's done. A ladder needs 10 feet. I'm interested in why that didn't meet the burden when there was nothing on the other side except a suggestion, not from an expert, that you could use the front and the back. I mean, presumably, Hack cares if there's a fire in this place. So why did they remove that condition?
I believe there was no dispute that there was access to those buildings from the front and the back.
There are sprinklers in the middle and not on the end unit.
Correct. We believe so. We believe so.
Oh, you believe so? So you've decided there's not going to be a fire, even though an expert came in and said you need to have a place for a ladder. Hack believes that there's no sprinkler, but that's still okay? Why does Hack believe that?
Well, the question is more, why didn't the board provide evidence that there was or was not? There was no definitive evidence.
They have to not only show that have an expert say you need a ladder, they have to have the expert say, and nothing else will work here, even though there's a front and back, because there's no sprinkler system, in response to something someone says later at the hearing.
I believe there were two separate ways of addressing that issue. Mm-hmm. One was that the witness for the board conceded that a ladder could be placed there, albeit with some difficulty. He also conceded that there would be access from other sides of the building, which would make it the equivalent of any other building with a middle unit.
Except for no sprinkler system. A middle unit, front and back access is okay, but they have a sprinkler system, presumably because it's not as good as something that has 3 sides you can bring water in from.
Again, there was no evidence that posed a serious danger, given the other access points to the system, to the building, and given the fact that it wasn't definitively shown that there would not be a sprinkler system. The board had the opportunity to make that point, but it did not.
Did you make a showing before the ZBA, or did the developer make a showing before the ZBA that you didn't need a 10-foot ladder?
I can't answer that question, Your Honor. We didn't have access to the ZBA proceedings for this. The focus, again, because it was a de novo evidentiary hearing, the board had the opportunity to present all the evidence it needed to overcome its burden on any of the conditions that were struck, that the board wanted to avoid getting struck. And they had extensive testimony on all those issues, but they just didn't meet their burden on any of the ones. And I will say, I suggested the court look at the decision of the committee, which is extensive and addressed in great detail the arguments that were given by the board, the counter-arguments given by the developer, and its conclusion based on its evaluation of the evidence on every issue that is now in contention.
Okay, your time has expired, but
Very well briefed by both parties.
thank you very, very much. Yes, very helpful arguments to us. This is a highly complex question, at least it seems so to me. I don't know, maybe someone thinks it's simple, but it doesn't look that way to me. Thank you very much. So the case is submitted. The next matter is number 24643, and this is Vento v. Vermont Mutual Insurance Company. And I believe we will hear first from Attorney Koldis.
Good morning, Your Honors. Gregory Koldis on behalf of the appellant Mark Vento. This case arises out of a catastrophic fire that was suffered at Mr. Vento's home back in 2012, and a dispute regarding how the insurance company, his insurance company, dealt with handling the claim relating to his damages. He filed a complaint asserting 4 counts: negligent infliction of emotional distress, breach of contract, and a Chapter 93A claim under Section 176D. The appeal in this case is in regard to a decision by the lower court to basically dismiss the negligence claim and the breach of contract claim.
And that was on the eve of trial, right?
That was on the eve of trial at a pretrial conference.
Before that, there was a summary judgment decision in which the judge denied allowed it as to the infliction of emotional distress, but denied it as to breach of contract, negligence, and 176D, correct?
That's correct. And in regard...
What changed, if anything, in your view, between the time of that summary judgment decision and the allowance of the motion in limine or motion to dismiss?
In regard to the negligence claim, Your Honor, I'm not sure that anything changed that I'm aware of in terms of how that resulted, other than at the pretrial conference hearing in response to the motion filed by Vermont Mutual to dismiss the negligence claim. The court seemed to say that that negligence claim was subsumed in the Chapter 93A claim.
Same with the breach of contract.
And the same with the breach of contract, except in the breach of contract case, there was no motion filed, and the court did that sua sponte.
So let's start with the breach of contract claim. As I understand your argument, I don't have the summary judgment papers before me, but I read the judge's decision, reviewed the amended complaint, reviewed your brief, and it seems to me your breach of contract claim essentially alleges 3 things. Number 1, they failed to act reasonably, they failed to make timely payment, they failed to make full payment, and they made us litigate in order to get what should have been obvious. Is that essentially correct?
I believe that's essentially correct, Your Honor, yes.
All of those issues were precisely what was tried in the 176D case, with very specific instructions provided to the jury that mandated a finding of an undue and deceptive act if they found that the insurer was unreasonably, made us litigate, et cetera. So if we were to agree with you and retry this, send it back, what would you be retrying? It seems to me it would be the exact same trial involving the exact same facts, except you might have different jury instructions. So tell me what would be different.
I think that's correct. You might have different jury instructions and the opportunity for the jury to consider a potential breach of contract that didn't necessarily rise to the levels of what's stated in Chapter 176D.
What does that mean? I'm not sure I understand what you're saying. You mean because the state of mind would be different? Or you mean there are other ways in which the contract was breached that aren't listed in the 176D?
I think there may be other ways that the contract could be breached that aren't listed in Chapter 176.
Could be or could have been breached.
Yeah,
Not that you alleged. Your allegations are the same for breach of contract as they are for 176D, correct? That's how you pled it, and that's the information that you argued before Judge Halal.
That's correct, Your Honor, but the 176D falls under the 93A claim, and the 93A claim, I think, implies some obligation to show that there was some unfair, deceptive practice.
Get that. But the judge's instructions, and I'm sorry to interrupt you, but I want to get to this point. This is Record Appendix, volume, it's actually just the Record Appendix, pages 470 and 471. The judge instructed, if insurance company committed one of these specific acts or omissions, the things which you allege are the breach of contract, the law declares it to be unfair. And then he specifies them on page 471 and says, if you find the insurer did violate any one or more of these provisions, you must find that the insurer committed an unfair, deceptive act. How would you get a more favorable instruction in a breach of contract case?
Well, Your Honor, I believe that the contract includes an implied obligation to
good faith and fair dealing?
Good faith and fair dealing.
But you didn't plead that as a separate count. You didn't plead breach of good faith and fair dealing as a separate standalone count.
That's correct, Your Honor. The complaint didn't include that count. But again, the contract, I think, would imply an obligation of good faith and fair dealing, and there may be circumstances in terms of good faith and fair dealing that don't necessarily rise to the level of what's stated in Chapter 176D.
But your good faith and fair dealing would be over the same, would involve the precise same claims, which is you didn't reasonably settle, you didn't pay in full, and you made us come after it. Correct? That's the foundation of that claim.
That's correct, but the jury might have also been allowed to determine that there was substantial delay that didn't necessarily result in the delay that referenced under Chapter 176D, but that there was substantial delay in settling this claim or in responding to this claim that resulted in damage, both to the property, because the property went, this fire was in 2012 and we were trying this case in 2024. The property was unoccupied, uncompleted, unheated, and again, I think the allegations are fairly state that there was damage to the property by the ongoing delay in terms of getting this matter resolved, or in terms of getting to the point of the trial. In addition to which, the claims of intentional infliction of emotional distress. So I think that had the jury been allowed to look at just a breach of contract claim, that they may have concluded a breach, even on what was submitted, as you say, what was submitted, they may have been able to conclude a breach that resulted in damages that, they find out ultimately the claim was paid. So, whether they say that, well, the delay wasn't so much that was a problem, but they could find that there was a breach of the contract in that delay in terms of resolving this claim, and that delay resulted in damage.
Can the contract have been breached negligently?
I think, yes, that's the negligence portion of the claim. That negligence count was...
I'm asking if the contract can be breached negligently. Would you win on breach of contract if they did one of these things, but they did it negligently rather than intentionally?
I think the distinction between the negligence claim and the contract claim is a little blurred to me, Your Honor. I think that, I think the contract imposes a duty to act certainly in a certain way, and that if you don't act in that way, that you're subject to the negligence claim, but that also could be a breach of the contract claim. So I think that both kind of can be true.
What's the limiting principle on that? And by that I mean this. If we were to accept your argument, I would be concerned that any breach of contract where there's an allegation, hey, you performed, but you didn't perform fully and fairly. I mean, I understand that could give rise to breach of the covenant of good faith and fair dealing, but it seems to me under your theory, virtually any breach of contract case could also be couched with a separate action for negligence without limitation, and I don't think that's the state of our law.
I think there are cases that deal with the breach of contract case in an insurance situation that also go to potentially the negligence aspect of it. So again, it seems to me if you have a contract, you have certain duties that, yes, you may, if you don't perform those duties, that's a breach of the contract, but if you fail to perform those duties...
Is your best case on that the Hartford case, Hartford Casualty?
I believe, yes, the Hartford case, Your Honor. And that, if you don't perform those duties appropriately, that there's a basis for a negligence claim as well. So I don't know that this case is opening up that area more than it already exists in terms of the ability to claim a negligence claim and a breach of contract claim.
The Hartford case involved an excess insurer versus an insurance company. Are there any cases like Hartford that involve a customer and a primary insurer?
Your Honor, I'm not aware of any case in Massachusetts that deals with a first-party claim against...
First-party claim's better nomenclature, thank you.
Yeah, against an insurer. There are the third-party claims.
Why is that?
Well, Your Honor, there are two cases in the federal district courts, one out of New Mexico and one out of Rhode Island, that do address a negligence claim in the face of a first-party negligence claim against an insurer. And in the, I believe it was the New Mexico case, they concluded that the fact that it had never been before them or never been broached before the courts in New Mexico before as some support for the fact that there was no claim, no basis for the claim. I'm not sure that that's a valid way to determine whether the law should support a claim, but certainly in Massachusetts there's no similar determination of that.
There's no issue raised here that, or maybe there is. Is there an issue raised here that you shouldn't be able to bring, aside from the 176 and 93A, the negligence and the contract claim? The court didn't say that those two were duplicative of each other, only that each was duplicative of 176D, is that right?
I believe the court held, yes, that they were both covered under the 176D claim. And looking at the statute on 176D, certainly it does list various ways that the contract can be breached, and those various ways that it lists, it declares them to be unfair and deceptive. But there's nothing in the statute that says that it's intended to be exclusive, and that that's the only basis upon which there could be a breach of contract claim, or the only basis upon which there could be liability for either breach of contract or negligent performance of the claim. In regard to the breach of contract claim, again, that claim was dismissed sua sponte by the court without any opportunity, certainly, to brief it or to respond to any kind of a motion to dismiss or a motion for summary judgment. As Your Honor pointed out, there was a prior motion for summary judgment, and where those claims were allowed to continue, So the determination by the court, I think procedurally, to dismiss the claim sua sponte, I think was inappropriate procedurally, certainly to deprive Mr. Vento of the opportunity to have the jury hear kind of every possible claim that he could bring in regard to this matter. Again, the inclusion or the subsuming of the breach of contract claim into the 176D claim pretty much is a determination by the Superior Court that that Chapter 176D is the only way you can bring a breach of contract claim with regard to the performance of the insurance
Well, it depends
contract.
what the facts are, I would think would be the response from the court. If the facts that are alleged only amount to things listed in 176D, I take it they're saying, then you don't need a breach of contract claim, because if any of those things happened, then you'll get 176D, an automatic 93A judgment.
176D, though, Your Honor, I think is not necessarily quite as definitive as that 176D Section 9 that lists out the categories of things. Says, in paragraph F, failing to effectuate prompt, fair, and equitable settlement of claims in which liability has become reasonably clear. So if there's lack of good faith,
but the judge listed a bunch. The judge listed misrepresented pertinent facts or insurance policy provisions, failed to acknowledge and act reasonably promptly upon communications with respect to claim arising under insurance policies, refused to pay claims without conducting a reasonable investigation based upon all the available information, failed to affirm or deny coverage of claims within a reasonable time after proof of loss statements had been completed, failed to effectuate prompt, fair, and equitable settlement of claims in which liability has become reasonably clear, compelled the insured to institute litigation to recover amounts due under an insurance policy by offering substantially less than the amounts ultimately recovered in actions brought by such insured. Right, there's a list. And if it covers every, I mean, obviously we have to look at the complaint. There's well-pleaded complaint rule. The legal theories in the complaint don't matter, but the facts do. And if the facts alleged are covered by each of these things, why do you need a breach of contract action?
well, again, the breach of contract goes toward the obligation of good faith and fair dealing, and part of the language of Section 9 of Chapter 176D talks about, in paragraph F, failing to effect prompt and fair, as you cited, once liability has become reasonably clear. So is it a possibility that there's a not good faith determination that liability is reasonably clear, or a negligent determination that liability is reasonably clear, and the insurance company takes the position, well, liability is not clear, so we're not paying.
You're out of time, but if I may have one
Yeah,
final
sure, of course.
question. The judge instructed, this is Record Appendix, page 472, that loss causation is an element of 176D. Do you agree that if there was a negligence claim that was allowed to be brought at trial, or a breach of contract claim allowed to be brought at trial, substantially the same instruction regarding loss causation would have been required?
Yes, I believe that you would have to tie those two together, that the negligence or the breach that you're alleging would result in the loss.
All right, your time has expired. Very
you.
interesting argument.
Thank you.
Thank you. We will hear now from, I'm not very good at this,
May it
Attorney
please the
Monahan.
court? Good
Yes.
morning. I think still.
You got a minute?
I'm William Monahan. I represent Vermont Mutual Insurance Company with respect to the action before you. I'd like to begin my remarks to focus on the issues that Judge Neyman addressed initially, and that's, I think the important issue is the stepwise, to determine and explore whether or not the stepwise process designed to create a definitive record was established here. I think that's an important issue with respect to the sua sponte decision of the court to dismiss the contract action. In the appellant's brief on page 16, they allege that they only addressed the negligence claim when they argued the law allows a plaintiff to pursue a negligence claim separate and apart from the 93A and 176D claim. And then on page 17, they argue that though the parties discussed the breach of contract claim at the pretrial conference, Mr. Vento did not have the opportunity to put forth any legal or other arguments. I don't believe that's entirely accurate. I'm going to direct the court's attention to the record appendix at pages 42 and 43. That's the plaintiff's opposition to Vermont Mutual's motion in limine to set aside the negligence count. And in that pleading to the court, and this was argued to the court at the final trial conference, Vento stated defendant's motion improperly equates the obligation of the defendant to perform under a contract with the requirements of Chapter 176D to effectuate a prompt, fair, and equitable settlement of claims, in which liabilities become reasonably clear. When a party binds himself to a contract to do work or to perform service, he agrees by implication to do a workmanlike job and to use reasonable and appropriate care and skill doing it. Goes on to make an argument on the second page that argues the distinction between tort and contract liability as between the parties to a contract has become an increasingly difficult distinction to make, citing Prosser. The contract issues and the negligence issues were addressed by Judge Halal.
You didn't raise the contract.
Pardon me?
It was sua sponte. You didn't, whatever they said in their response, you didn't raise dismissal of the contract claim, right?
I did not.
Okay. Can we skip to the negligence claim, which seems more interesting to me?
Sure.
Okay. The jury were instructed. The plaintiff has the burden of proving by a preponderance of the evidence that the defendant had a subjectively culpable state of mind. Willful or knowing requires something more than mere negligence. How can that be duplicative of a negligence claim?
As far as the negligence count is concerned, Your Honor, I don't believe Vermont Mutual or any insurance company has a duty on a first-party claim to an insured.
Not to be negligent. Because I have cases that say there's no such thing as a negligent breach of contract, because if you breach a contract negligently, it's a tort. I have a couple cases that say that from the state SJC. So I don't, you think you can be negligent with your insureds?
Absolutely not.
Okay, so
I believe an insured is protected from such conduct under the guise of Chapter 176D, which was promulgated.
Instructions here are that you have to have culpable conduct. Negligent isn't enough. So they're not protected under these instructions.
I believe they are, Your Honor, when you consider the facts that were developed during the course of the trial, and when you read the judge's instructions given to the jury with respect to applying those facts to Chapter 176D and the subsections of Section 3, subsection 9, I believe the insured is protected from any such conduct.
What instruction do you have that says negligence is enough?
What instruction do I have?
What jury instruction do you have where the judge says, if you find negligence, you can find these 176Ds?
I don't believe the judge said that.
I don't believe so either. I think he said the opposite. Or she. I don't know who the judge was. Do you disagree with that?
I believe the term negligence has to be applied to the facts of the case. And
the jury were told negligence isn't good enough to find liability. let's say they apply the facts of the case, they look and they say, oh, I don't think it was culpable, but it was negligent.
Negligent as to what, though?
Let's take any example in any insurance contract. You negligently didn't show up in a timely way. You negligently offered too little, even though it was reasonably clear that more was needed. There's a million things an insurance company can do negligently.
I understand. I do not believe, at least with respect to your first option, if someone, an adjuster, doesn't show up to an appointment on a timely basis, I don't believe that's actionable.
What if it turns out that the insurance company doesn't actually have a calendaring system? And so they didn't send the person out in a timely way, and they needed them to do it because they had to do repairs in an early way, or they were losing money every day or something. Surely there's something negligent that an insurance company could do, resulting in failure to comply with the contract.
Yes, and I do believe that that conduct is theoretically addressed under the penumbra of Chapter 176D, Section 3, Subsection 9, and the subsections that address specific codified conduct on the part of insurers. And what I don't believe this is intended to be an exhaustive list as to conduct that an insurer may or may not perform. But I believe it was the legislature's intention to make these bad faith cases easier for consumers such that the proof under Chapter 93A, the 176D statute provides a roadmap for insureds to address the conduct of an insurer if they believe they've been wronged. And I don't know if
Do you have another case where a negligence claim was kicked out because there was a 176D?
In Massachusetts, no.
Well, Massachusetts is where 176D is the law.
Yes.
So
And when you say 176D, I'm thinking bad faith. I'm not thinking specifically with respect to 176D.
Let me ask that a different way. Justice Rubin's question's a very good one. In the Hartford casualty case, as I read it, it basically says, I'm paraphrasing, but in the context of an excess insurer vis-a-vis a primary insurer, in certain circumstances, both a 176D claim can be brought and a negligence claim can be brought. Is that correct?
Yes.
Are there any cases which discuss the same principle except between a primary insured, an insurer and a primary insured?
Not that I'm aware of.
Why is that? I mean, it seems like something that would come up all the time, and I can't find Massachusetts precedent on point, at least not yet.
I believe first-party property cases are a very different animal from a third-party liability case. And that Hartford casualty case, as you indicated, was an excess versus a primary insurer, and it was a failure to settle. Theoretically, it was a failure to settle.
So the law protects primary insurers more than it protects consumers?
No.
Okay, keep going.
But to answer your question, I can't answer your question as to why.
It either makes it a very good or a very poor question. I'm not sure which.
No, I think it makes it a very good question, but I don't know why first-party property cases have not percolated up to the appeals court or to the SJC on that issue. I cited in my brief the Maloney and the Lackey cases, obviously in a different jurisdiction, but I've advanced the reasoning that the courts discussed and addressed in those cases, and I'm asking this court to consider adopting that standard vis-a-vis and fully understanding, as Judge Rubin indicated, every case is to be addressed. It's a fact-specific issue. But specifically with respect to this case, the issues that were addressed and developed by the plaintiffs and which the appellee responded to in the context of pleading negligence and pleading a breach of contract, were nothing more than a restatement of the Chapter 176D claim. And I believe Judge Halal in the lower court gathered that through a variety of sources. He reviewed the amended complaint. I'm sure, and because I know he reviewed Judge Kirpolani's June 29, 2021 order. He had the benefit of the joint pretrial memo, which is at the record of supplemental appendix 13 through 26. And based on those documents and based on the exhaustive final trial conference that we had before him, which I believe is at record appendix 60 through 106, that if the court focuses on just what Judge Halal had at that moment in time, I believe that he did in fact create the stepwise process to address whether or not it made sense for the purposes of this trial to give to the jury a breach of contract count, a negligence count, and a Chapter 176D count. The last issue I wanted to address was the fact that, as I understand it, Mr. Vento's negligence claim, he's seeking economic damages. And I believe under the Massachusetts law, these economic losses I do not believe should be recoverable. And I've outlined that in the brief. These damages that he was claiming to recover against Vermont Mutual, who did not cause him to suffer personal injury and who did not cause him to suffer property damage, are not actionable. The amounts paid to a referee, the lost rental income, the incurred rental expenses, and the depreciation, which he ultimately did not recover, I don't believe are recoverable.
You didn't raise that below, did you?
Pardon me?
You did not raise that below.
I don't believe I did, Judge.
Okay.
And with that, unless the court has any other questions, I will rest on the brief.
I see none. Thank you very much. Thank you both. Interesting case. It is submitted. Our final matter for this morning is number 24554. I remind the attorneys that this is an impounded case, and so don't use the names of the people involved. We can say things like mother, twins, child 1, child 2, and so forth. It is DCF and others versus mother and another. And we will hear first from Attorney Queiroz.
I'm just going to put down the mic. Sorry, I'm a bit short. Good morning, afternoon. May it please the court, my name is Christine Hamilton Queiroz. I am here on behalf of the appellant mother. After the visitation hearing in February 2021, with the evidence and the testimony fresh in the judge's mind, the lower court opined the quality of the evidence in that last case was horrible.
This is cut off, this is after the case is already heard, and this is just caught on the FTR.
Yes.
Right, when
after
the parties
the
are not
hearing,
present.
at
Kind
the
of
end
off
of
the record, but not really
Yes.
off the record.
You should have heard the therapist was like a therapist in training. I mean, do I think the children are suffering? Yeah, but I don't think they've proven their case. The clerk then says, that mom's been around a long, long time. I remember her from a long time ago, to which the lower court responded, yeah, this prejudgment based on mother's history bled into...
Yeah isn't how that ends.
What's that?
It doesn't end, yeah.
Well, she
Yeah,
says-
I wonder why there hasn't been a trial yet.
Yes.
That doesn't
yes.
have anything to do with wondering why this hasn't gone to trial. Has nothing to do with the visitation question.
I would say it does, Judge.
Well, how would you show that it does?
Because despite her thinking that the evidence was horrible, she then turned around and terminated mother's parental
She
visits.
spent a week thinking about it, right? The order didn't issue for another week.
That is correct.
Well, go ahead, no.
So this prejudgment did bleed into the motion to terminate visits. Because despite this assessment...
Prejudgment that there had been no trial yet and it was a long time? I don't understand how prejudging that bears on anything.
I'm sorry, I didn't hear the last part.
I don't understand how the only judgment she seems to have suggested was that it had been a long time without a trial. Now, if she'd set a trial date, then maybe that would be...
I apologize, Judge. That's my fault. So by prejudgment, I mean that she prejudged the evidence, saying that it was horrible, and that the therapist's testimony was that of like a therapist in training. So that's the prejudgment. She judged the evidence right then and there, with it fresh in her mind.
Well,
And it
but
was...
this is just right after the hearing ended, right? But then,
Yes.
as Justice Rubin mentioned, a week went by, presumably, but we don't know, right? And I don't think it's in the record at all. She took it under advisement, may have viewed exhibits, she issued a decision, a written decision, right, after
I don't think there were
consideration.
any exhibits. But yes, she issued a written decision. However, that decision was not based on both, she didn't write child-specific findings for each child. She sort of conflated both children.
So can you just talk about, so you spent most of your brief, almost all of your brief, and you started your oral argument today talking about the visitation motion.
Yes.
So are you challenging any of the judge's findings of fact or findings of law at the termination hearing?
So for the termination piece of the judge's final determinations, the fact that the judge had terminated the parental visits weighed heavily in the determination to terminate her rights.
But can you, so my question was, though, are you challenging any of the findings that the judge made?
Well, one of the glaring findings based on the evidence was that the judge said that mother made no progress. And that just is, if you look at the judge's findings, that's not the evidence. She had made progress. And the case law says that the judge, for example, she was reunified with her baby. She had unsupervised, prolonged visits with her other child. And under Linus, the court has to consider that in its findings. That is progress. That's not no progress. That is progress.
Right, but can't you also, isn't there case law that also establishes that you can be a fit parent to one child, but not an unfit parent to another child?
That is true, but that's not what this judge found. She said that the mother made no progress. She didn't say that mother's fit for these two, but not the other two.
After visitation was suspended pre-trial, did the mother's lawyer bring forward any motion or try to get this back before the judge at any time?
No, she did not.
Can I ask a question? It's about remedy. You say that the visitation was wrongly terminated, and then you ask for a new trial. But since there hasn't been any visitation, won't it look exactly like the last trial?
Well, Judge, it shouldn't look exactly like the last trial. At this trial, at the last trial, the court, at the termination of visitation, the judge had said that the children were experiencing issues after visits. Now, at the trial, she made findings that she blamed all those issues on the visits. At trial, she made additional findings that not only had those same issues continued up through the entire case through trial, but that there were additional issues. So the daughter was experiencing night terrors. The son was still hitting and biting. He still had issues with eczema throughout the whole case. So taking that into consideration, along with the fact that the judge should have looked at the instability and inconsistency of the visits because of DCF pulling the visits back unlawfully, and she didn't...
DCF didn't do it unlawfully. They got a judicial order.
That's incorrect.
Well, for a period of time, they suspended, but then 2 years, 21 months before trial, they got a judicial order suspending or terminating visitation.
So in the summer of 2020, the department suspended visits. Mother brought a motion forward, an emergency motion. The lower court said a visitation isn't an emergency. Mark it up in due course. She did mark it up, and then by October, the judge said, you have to file a motion to suspend visits, or you need to give mother visits. And so when they restarted visits, when they planned to restart visits, the department didn't file the motion. They worked with mother on a plan to get visits back on track. The children's attorney filed the motion, and then 4 months later is when...
That's lawful, right?
No.
You think a child's attorney can't bring a motion to suspend visitation?
They can, but the unlawful part was that the department suspended visits without filing a motion and requesting a court order. I apologize. Under 110 CMR 7.128, the department has an ongoing obligation, and also under 110 CMR 101 and 102, to continually assess parent visits and report that back to the court, which they didn't do in those 22 months.
So is that a reasonable efforts issue?
It could be a reasonable efforts issue, but the fact that visitation is, under federal and state law, such an important, integral part of family integrity, it is its own issue.
So the mother didn't bring, she had many avenues, right, that she could have pursued, or her attorney could have, after the motion was allowed to suspend the visits, between the 21 months that order entered and the trial. And so there could have been a motion to reconsider, she could have filed an appeal, she could have moved to reinstate visits. There were 29B permanency hearings that happened, as referenced by, I think, Justice Rubin. There could have been reasonable efforts motions filed that are filed all the time, right? So there are many ways in which the mother could have sought remedy.
She could have, but that doesn't excuse the department's obligation to work with her, and it doesn't excuse the court's obligation to check on the status of its order and on the status of visits.
Are you familiar with adoption of Ilona?
Yes.
Okay, so in adoption of Ilona, the court says, even if reasonable efforts were wrongly denied, at the point of the trial, the judge has to look at the best interests of the child. And so it won't, even if it was error, it doesn't alter what the circumstances are at the time of trial. Why shouldn't this be the same, treated the same?
Well, Judge, that's a good question. I think looking at the conclusions of law in particular, this judge didn't really answer that question. She looked at the behavior of the children at the visits, which was 21 months, 24 months before the trial, and then 2 years before the findings. And in the conclusions, there's 38 conclusions of law, 12 of those rely heavily on those terminated visits. That's 2 years prior. That's stale evidence. Also, even though 15 of those conclusions of law were case-based, they didn't really refer specifically to mother. 2 of the other conclusions of law relied on mother's history. So, and some of that included the other children, so I don't think that
Which is permissible, though, right?
I'm sorry?
That's permissible, right? A judge can appropriately consider prior history.
It is, but it can't be the sole reason, and it shouldn't be the major reason. There has to be current, it has to be current information, current facts.
Doesn't mother, I'm
Go ahead.
sorry.
No, please.
Doesn't the judge make findings that the mother didn't benefit from working with a recovery coach, didn't gain insight into her, on working with anger management, domestic violence services? She made, I'm not going to state all of them, but do you concede that the judge did make other findings to support unfitness?
Yes, so she did. However, the standard isn't that the parent has to be a perfect parent or even a good parent. They just have to be a minimally fit parent. And she was minimally fit to have at least custody of one child who was younger than these children and unsupervised extended contact with her other child, the second to youngest child. So where I do concede that there are findings that say mother engaged in services, and she did have slip-ups and issues after that. They weren't so bad that she lost custody of any other children. And even if a parent uses alcohol or substances, it has to, that in itself isn't per se unfitness.
But it's leading to police interactions a lot.
It had in the
At
past.
the time of trial, though, right? Didn't she have an incident with her oldest child in which she threatened her daughter and threw her out of the house? It appeared to be under the influence at the time?
Well, the police had been called at 1:30 in the morning with her 18-year-old daughter trying to break in curfew at 1:30 in the morning. I'm not sure that any findings can be based, that one can assume that she was under the influence of anything with someone knocking on her window at 1:30 in the morning, waking her up out of a dead sleep. I would say that, I wouldn't say that there were no findings about that. There were no findings saying that. So, the lower court also, when it did terminate the parental visitation, it didn't acknowledge that the department it didn't acknowledge the rocky nature of the visits prior to that, and that maybe there were other causes for the children's behavior and other causes of the stress that the children were going under, such as the changes in daycare. That there was a new baby at the foster home. They had been in a car accident with the foster mother. There had been disruptions because of COVID changes in visits. Then they started in-person visits, and those were disrupted from DCF stopping and starting and stopping and starting them.
Was the mother's gift giving during the period when there was no visitation?
I'm sorry?
She gave gifts or sent gifts, and the children reacted negatively to the gifts. Is that during the 21-month period after visitation ends?
Yes, it was, Judge, and I would say that, like the hearing to terminate visits, almost all of that information is coming from the foster mother, who was not only trying to adopt my client's children, but also have placement of the new baby that had been born. So,
No, I get that, but that kind of credibility question, obviously, there's always risks, of dissembling on lots of people's, I hope they don't, they're under oath and so on, but the judge has to weigh that kind of credibility stuff. We don't see the witnesses.
yes, Judge, yes. So mother is asking for the judgments terminating her parental rights be vacated and that the case be remanded so that services can be put into place to assess mother's relationship with the children and whether the visits would be in the children's best interest, especially given how their behavior has gotten worse since the visits stopped. It may be that the children need closure and need to see mom, and I see that my time's expired.
Your time has expired. Thank you very much. We also have your brief, which is excellent. So thank you for your argument. We will hear next
Thank you.
from, I gather you all are splitting your time with the AAG getting 8 minutes, is that right?
Yes.
And first? Okay, so we'll hear from Attorney Gallup.
Good afternoon, Julie Gallup on behalf of the Department of Children and Families. This court should affirm the decree of the lower court. Mother's unfitness was overwhelming. These children were removed in 2018 after she had been using crack cocaine and intravenous heroin for 2 nights, and then she got into a head-on collision in a school bus. Now, to Mother's credit, she did get into long-term substance use treatment, and she was in various programs, including a sober home. But despite those efforts, she then still continued to use substances, and more recently...
You mean alcohol?
Yes, yes.
Okay, but we don't have evidence that she's continuing to use illegal drugs, is that right? The judge didn't find that she's continuing to use illegal drugs.
That is correct. There was a relapse in 2019, and there was a positive screen for fentanyl, then norfentanyl more recently. But at the time of trial, the judge's concern was with regard to Mother's alcohol use, which she testified she did not have a problem with, but substance treatment providers had diagnosed her with alcohol use disorder that was active. So, in the face of all of, in addition to the alcohol use, there was also her anger, which, to her credit, she did engage in services, but combined with the alcohol use did lead to police responses and criminal charges. So to say that Mother was denied of an opportunity to rebut the department's evidence because the visits were terminated in 2021 before trial, there was, in the face of so much overwhelming unfitness, there's nothing that...
I'm not sure you've described overwhelming unfitness. I'm not saying that there isn't unfitness by clear and convincing evidence. But drug addicts who stop taking drugs, which by hypothesis is what we're dealing with here, that's substantial progress. Like initially you described the terrible things, but they were drug-related, right? And then at the time of trial, I think she has either 1 or 2 of her children, 1 child in custody and 1 she has unsupervised visits with. I understand that maybe that's Rhode Island's judgment. I don't know who is deciding what in this case, but I don't know that it's so. I mean, we've seen more overwhelming cases, unfortunately.
I think that, to Mother's credit, she did cease using narcotics or, illegal substances. But the fact that she, was testifying that she did not believe that she had a problem with alcohol in the face of, recent police involvement, the 2022 incident that I don't remember was just asked of my sister. The police determined that Mother was intoxicated, and so, when she's telling the court, I don't have a problem with alcohol, the judge it would be a difficult decision to find that would be a safe caretaker who doesn't have the insight to understand that actually there is a potential, there is a problem here. It is impacting her behavior, police are being called, and, despite her participation in services, unfitness, the judge correctly found that it had been established. With regard to the and I will say that Mother's argument that she was unable to explore the various, now switching back now to the visitation hearing.
Mother did cross-examine the various witnesses and called witnesses herself, and she did explore the different reasons the children could be having potential, their behaviors could be something other than caused by the contact with the mother, and, did ask questions about the new baby in the foster home, asked questions about the car crash with the foster parent. So Mother, had these opportunities, and the judge, weighed the evidence and determined that that the children had established by clear and convincing evidence that visits were harmful.
There's some question as to whether this was a suspension of visits or a termination of visits. Can a judge order a termination of visits or only a suspension?
The judge can terminate visits. That is, that's adoption of RONA. There are, I couldn't find a case that actually talks about suspension, but researching that, it is mentioned in dicta in various cases as something that has occurred,
What was the motion seeking by the Children's Council? Do you know?
It was, I believe it was titled to suspend, and I know that my sister does kind of argue, discuss whether it was a suspension or whether it was termination. Looking factually, there was a suspension from from February until May, and then once the court found that there was, that there was harm to the children at that point, then it was terminated. Mother had an opportunity to appeal that order. In fact, the judge said, these are my findings. I will, if this is appealed, I'll make more findings. Mother did not appeal that. And to Justice Tan's point also, Mother had an opportunity to raise this, through various motions, including at the 29B permanency hearings. So,
in any party, not just the parent, right? The department, if you determine the mother has made enough progress and could come forward, and the children as well, right, could come forward at any point and make a motion to reinstate the visits.
I mean, that's my understanding. There's nothing preventing them from making that request to the court. And in fact, if it was something that any of the parties determined, was supported by whatever evidence they had at the time, then I would hope that, they would make such an argument or, request such relief. Also, I mean, with regard to the visitation, I have argued it and addressed it, but I believe that all of those arguments are waived. Being subsumed into the trial itself, Mother had an opportunity to present.
You can raise an interlocutory order after a final judgment, right? So they're not waived in the sense that Mother's prohibited from raising them before us. But what we can do about it may be dramatically different than what could have been done with an interlocutory appeal.
Certainly. I guess I think the waiver, I perhaps didn't present in the most artful manner just now, but I think more in my brief I do discuss how, the delay, the issue of the delay, that was certainly waived by not even bringing this to the court's attention when they were scheduling the motion.
Your time has expired, and I see no further questions. Thank you. Excellent argument.
Thank you.
And we will hear finally from Attorney Taylor.
Good morning, Your Honors. Hannah Taylor on behalf of the children. The children are asking this court to affirm the trial court's judgment, finding them in need of care and protection and terminating Mother's parental rights so that they can be adopted by their current placement where they have been for nearly 7 years. The court properly found clear and convincing evidence of Mother's unfitness, as well as that the children's best interests would be served by being adopted by their current placement, which is fully meeting their needs, including substantial emotional and behavioral needs. It is also the children's strongly expressed preference that they be adopted, and I did meet with them most recently this past Saturday. I would like to focus my argument today on
You met in person?
Yes.
And they are still in the same placement they were in at the time of trial?
They are, yes, Your Honor. I'd like to focus my argument today on the propriety of the termination of parental rights and any questions the panel may have, but I would first like to briefly address the issue discussed about the court's off-the-record comments following the suspension hearing. This was not cited in my brief, but the case of Commonwealth versus Spencer, 465 Mass 32 at 45 to 46, notes that reviewing courts look to the judge's thorough written decisions made after consideration of arguments at the hearings and the parties' paper rather than the type of thinking out loud type of comments made while grappling with a decision that must be made. I would also like to just briefly correct a couple misstatements of fact. The February 2021 suspension of visitation was 16 months prior to the beginning of trial. In June of 2022, it was not 21 months prior to trial. As well, the June 2022 police incident involving mother's oldest daughter was not about breaking curfew. The police report notes that mother stated to them that her issue was that the child, in her view, had been disrespectful about her new boyfriend. And not only did the police have to attempt knocking on the window, but they also nudged her with a shovel for several minutes before she awoke, and that when she did finally speak with police, she continued to be hostile and yell at the child in front of the police. As to the gift-giving question that Your Honor had, I don't know that it's entirely clear from the record when that issue occurred, but it is at finding 233. That finding discusses 2 years of gift giving, so presumably one would have been December of 2021 after visits were suspended, and the previous one would have been December 2020 during visits. And so with that, I would like to turn to the propriety of the termination of parental rights. So the court properly found clear and convincing evidence of unfitness, supported by meticulous fact-finding. There were 238 findings of fact, none of which, as Your Honors noted, have been contested. Each were supported with citations to the record. The most relevant groups of findings to unfitness would be mother's ongoing issues with substances, as well as her inability to meet these children's special needs. And her issues with substances at the time of trial were primarily alcohol, and as Your Honors noted, involved multiple police interactions, including acts of violence by mother, which were witnessed by children. There was an incident in February of 2021, which ultimately led to her conviction, in which she was found in which the police observed her repeatedly smashing a woman's head into the floor. Her second oldest child, who was 7, and her youngest, who was 7 months, were present in the apartment at the time. The following month, in March of 2021, she was again arrested for being intoxicated and allegedly committing an assault and battery at that point on her friend's daughter, the friend with whom she was staying. And there was not only a 10-year-old child in the home during that incident, but that 10-year-old child witnessed that incident. There was also an incident just prior to trial in May of 2022 where mother was intoxicated and yelled and swore at the police repeatedly such that they had to end the interaction. And then, as my sisters have both discussed, and I mentioned earlier, there was that other incident during the pendency of the hearing on the merits in June of 2022 related to mother's oldest child. And so mother has engaged in treatment intermittently, but unfortunately it has not, at the very least, rectified mother's issues with alcohol, which she, at time of trial, testified that she did not believe she even had any problems with alcohol. And her issues related to substances does impact her ability to parent. While the children were in her custody and care, they had been referred to early intervention, and in the intervening 18 months, mother never followed through on that. They had also missed over 40 medical appointments by the time they had been removed in August of 2018. But their needs continued after their removal, and mother unfortunately has an inability or unwillingness to meet those needs. And so in 2019, they began showing issues related to visits. It's unclear, what the exact cause of that was, why that began, but that's not the issue. The issue is how mother responded to that. So here she is faced with children with special mental health needs, with significant emotional and behavioral needs who are presenting as being in distress when they're interacting with her. And DCF and foster mother are both offering her resources to fix the problem. and she is rejecting them. And so her inability to work with the department in particular in order to do what needs to be done for the twins to be emotionally safe with her ultimately is what renders her unfit. And some of those efforts, DCF referred the children to therapy. They met with mom about the need to be in quiet places. They met multiple times, I think 3 times with her about the children's needs, including once with the children's in-home therapist. There was also the March 4th, 2021 foster care review which was during the evidentiary hearing on suspension, where DCF indicated that they had offered mother to speak with the in-home therapist specifically about, so she could understand the twins' needs and traumas, and she declined that offer. And she also did not see the need for a parenting assessment. That was ultimately explained by a social worker, and she apparently agreed to do it, but then never did by the time of trial. And so she is unable to even appreciate the twins' significant emotional needs, yet let alone meet them. And those needs are substantial. Both children have night terrors. The son was engaging in instances of self-harm. The daughter would be completely shut down. She would just stare at the ceiling for long periods of time. They both have needed in-home therapy services. They both have been referred for individual therapy. They both qualify for individualized education plans related to their emotional needs. And so mother's unfitness has to be considered in the context of the twins' special needs that may not exist as to her other children, but did exist, I would argue, as to her eldest child, who also had substantial emotional needs, and that the court also found she failed to understand.
Okay, your time has expired, but if there are questions, no. Thank you very much, all 3 of you, for excellent arguments. These are, of course, the hardest cases that we see given the stakes and what's at issue. So your arguments are very much appreciated. That brings us to the end of our sitting for today. I'd like to thank the court staff, who I can't really see, but who I believe is helping us, and the court officer for his and their always excellent work. We stand in recess.